Good morning. Welcome. Today we begin a two-day public hearing to explore the current state of competition in the railroad industry and possible policy alternatives to facilitate more competition where appropriate. There's been broad public interest in this hearing, and we have already compiled an extensive record. I want to thank everyone who participated for their thoughtful comments. Many have heeded my call to work to find solutions, and many have provided us with ideas worth considering. Competition lies at the heart of the balance contained in the statute we are governed by, the Interstate Commerce Act, as amended by such laws as the Staggers Rail Act of 1980 and the Interstate Commerce Commission Termination Act of 1995. It directs the board to allow, to the maximum extent possible, competition and the demand for services to establish reasonable rates for transportation by rail, and to minimize the need for federal regulatory control over the rail transportation system. That is, our system relies on competition in the first order to regulate the railroad industry. Our economic regulation largely serves as a backstop for shippers where competition does not exist. And for many shippers, this has worked well. The U.S. freight rail system is the envy of the world, providing transportation efficiently and in an environmentally friendly way. Shippers served by two railroads or who can move their goods by other modes generally should get good service at reasonable rates. But for some shippers, competition for their business does not exist, and the board must provide a forum for regulatory relief from unreasonable rates and practices. The board has worked diligently over the past several years to ensure that those regulatory processes are working by reforming large rate cases, establishing new rules for smaller cases, and issuing orders on unreasonable practices. I commend my predecessors for their work in what is always an ongoing process. The law also contains provisions that allow the board to take additional action in certain circumstances to facilitate rail-to-rail competition. For example, the board has authority to order carriers to provide alternate through routes to provide shipper service over a different route than the ones carriers offer to them. The board may order reciprocal switching services where one railroad switches traffic to another carrier that carrier cannot physically reach. And the board also has authority to order terminal trackage rights to allow one carrier to physically operate over the terminal tracks of another carrier to serve shippers. One area that this board has concluded in the past that it may not have full authority to order relief was to require railroads to quote bottleneck rates. That is, the agency has ruled that it cannot routinely order a railroad to quote a rate to a point on its system where it interchanges with the second carrier to allow a portion of the move to be subject to competition. Underlying all of these is the question of how the price of access should be set. These are the areas that we will hear about in the next 2 days. I don't think it is too debatable to observe that the railroad industry has changed in many significant ways since the board's competitive access standards were originally adopted in the mid-1980s. Railroads have seen improving economic health. Class 1 carriers have consolidated through mergers. The short-line railroad network has grown dramatically, and customers are participating in the provision of more capital, such as rolling stock. So it is important that we review these issues now. This country's economy has faced a serious downturn. It is no secret to anyone in this room that railroads play a central role in making our national economy work. Railroad employees are out there every day overcoming tremendous obstacles to allow our commerce to flow. Right now, railroads and their customers are facing historic flooding in parts of the country, working very hard to get our goods to market. The President has made U.S. exports a priority to lead the economic recovery. The National Export Initiative calls us to marshal the full resources of the United States government behind American businesses that sell their goods and services abroad. So one area I will be listening to very carefully is how our regulation affects exporters. Certainly, to be competitive internationally, exporters need excellent rail service at reasonable rates. We are also cognizant of the need to foster a healthy domestic economy as well. Of course, railroads need to earn adequate revenues to allow them to invest in their networks to make all of that happen. I look forward to the testimony. I know I have a lot of questions, and I'm sure my colleagues do as well. Before we begin, let me just take a few minutes to review a few procedural points about today's hearing. We have 2 full days of testimony scheduled. We ask all witnesses to please summarize their oral statements in the interest of time. I think I can speak for everyone and say that we have all read each of your full statements, and you should not feel obligated to use every second of the time allotted. And consistent with our practice, we will allow the witnesses on each panel to make full presentations before the members ask any questions. You will have a light before you at the front of the room. 1 minute before your allotted time, a yellow light will appear. When you see the red light, your time has expired. Please conclude your thought at that point. After the conclusion of the witnesses' presentations, we will rotate among the members asking questions. I would remind parties that this hearing is not the proper forum to litigate any specific pending matter. These issues touch many cases under consideration, but arguments as to the merits of any case are best left to those dockets. If you are scheduled to testify, please make sure that you check in with the clerk at the front of the room. I have also been asked to remind witnesses to please speak clearly into the microphone. In addition, the public should be aware that a video archive of the entire hearing will be placed on the STB website within a few days of the close of the hearing. In the unlikely event that we have a fire alarm or other event requiring evacuation, which we did at the last hearing, please proceed in an orderly fashion out of the double doors at the back of the hearing room and out of the building through the front entrance. Specific instructions have been posted at the back of the hearing room for assembly and notification of return, if any, to the hearing room following any evacuation. Also, a note regarding PowerPoint presentations. If you haven't done so, within the next 2 days, provide 2 hard copies of the PowerPoint presentation to the Office of Proceedings. Finally, if you have not done so also, please turn off your cell phones. With that, I will now turn it over to Vice Chairman Begeman.
I want to begin by commending Chairman Elliott for his leadership in calling this hearing on competition in the rail industry. This hearing was announced long before I joined the board last month, and I applaud the chairman and Commissioner Mulvey for recognizing the importance of taking a fresh, comprehensive look at these important issues. I'm glad to see that there are so many stakeholders that have taken the time to participate in this proceeding. I've had the opportunity to meet with many of you over the years on a wide variety of transportation issues. There are also many of you that I have not met, and I'm very interested in hearing from all of you. I'm not one who believes that all board policies and regulations are perfect. At the same time, however, any changes that might be considered must be fully and formally vetted prior to implementation. As you know, the Senate Commerce Committee has looked at many of these issues over the past years, and we relied heavily on stakeholder input when developing legislation. Your input here is equally important, if not even more important. I hope that all of you will approach this hearing in an effort to be constructive, not to simply defend or oppose the status quo, but to inform the board how specific proposals might reconcile, at least in some ways, the concerns of both captive shippers and the large railroads. Again, I thank the chairman, and I look very forward to hearing from all of you. Thank you.
Thank you, Vice Chairman. Commissioner?
Thank you, Dan. Well, this hearing has been a long time coming, and it will address issues that are at the core of the board's mission. How to ensure that an industry that is characterized by a certain degree of monopoly or duopoly is sufficiently competitive, either through market forces or through regulation, to promote reasonable rates and service, and also how to ensure that this capital-intensive industry, with most of that capital coming from private sources rather than the government, continues to have access to private capital markets. Over the years, the board and the ICC before it have used many different tools to address competitive issues with varying degrees of success. Pre-staggers, the ICC tried to balance the interests of the competing modes and to promote the inherent advantages of each mode of transportation. not with great success. Post-Staggers, and since overall transportation deregulation, the focus has shifted more towards reliance on market forces and less regulatory intervention. For example, the ICC adopted our current competitive access standards, requiring the showing of competitive abuse back in the mid-'80s. As a result, however, the railroads and shippers have spent the last 25 years arguing about it. In the late 1990s, the board decided to bottleneck cases, finding that a shipper cannot ordinarily require a carrier to short-haul itself by quoting a rate between 2 points less than the full origin-to-destination movement if the carrier, in fact, is capable of providing origin-to-destination transportation. In 1998, the board invited shippers and carriers to discuss competitive access issues with the assistance of a board administrative law judge. The result of that, no progress was made in crafting a new competitive access standard that shippers believed they could use or that railroads believed they could continue to prosper under. Despite these setbacks, the board has not given up in trying to address the fundamental competitive issues affecting both shippers and carriers. Today, we will try again with fresh perspectives and with open minds. The filings in this proceeding suggest that railroads and shippers are as far apart on these issues as ever. However, I believe that the board has a responsibility to examine its competitive access regulations, especially given the sea change in the railroad industry since its current policies were first adopted. My hope is that the parties today will put some of the entrenched rhetoric aside to explore mutually agreeable solutions to these thorny issues, rather than promoting only winner-loser scenarios. My hope is also the board will keep moving after this, taking the necessary hard look at the options and then finding the right solutions for today's industry and competitive environment. This nation depends on a healthy rail industry to move the massive amount of freight that ends up in our stores, our farms, and our homes. We also depend on the shippers of those goods not paying inflated transportation rates or enduring poor service. Two distinct possibilities in non-competitive market environments. When I meet with shippers, they often complain about the take-it-or-leave-it attitude exhibited by the railroads, a problem that can impact everything from rates to routes to car supply and even to demurrage. When I meet with railroads, they are concerned about having the revenue needed to invest in their infrastructures and to meet the extraordinary capital demands for capital, and to make the business decisions that are right for their companies. Neither side has a monopoly on being right. Finally, I want to note that I value thoughtful pleadings from all sources, whether it's a three-sentence letter from a small company that ships 10 carloads a year, or a 25-page submission from a Fortune 50 company accompanied by 6 expert verified statements. Many of the pleadings we received on both sides of these issues appear to be standardized, identical letters, in volumes I have not seen before in my 7 years at the board. And although I am pleased about the great interest in the proceeding, I hope that dueling form letters will not become a precedent for every major proceeding going forward. Our nation's trees deserve better. Thank you to all those who are participating on these next 2 days for sharing their ideas with us, and I look forward to this important discussion. Thank you, Chairman Elliott.
Thank you, Commissioner. Thank you, Vice Chairman, for your insightful and helpful comments. And now we will get the show on the road. First, we'll begin with Panel 2. And just as a matter of information, as you notice, Panel 1 is members of Congress when they arrive. So when they do arrive, we will interrupt and allow them to go forward due to their pressing schedules. So why don't we start out? I believe interested parties begin with 30 minutes, and you may begin at any time.
Thank you, Chairman Elliott. My name is Scott Stone. We're very happy to be here today to help you address this issue. And Vice Chairman Begeman, delighted to welcome you to the board. And Commissioner Mulvey, your insight is extremely valuable. I tend to think of you as Professor Mulvey, but just don't ask questions that are too hard for me today. I'm from Patton Boggs in Washington. With me today are Jeff Moreno of Thompson Hine, Mike McBride of Van Ness Feldman. Together we represent a number of trade associations who have filed joint comments. We've given this group of trade associations the very creative name of the interested parties. The interested parties comprise 26 different associations representing all types of shippers, including shippers of agricultural products, forest and paper products, coal, chemical, fertilizer, and mineral products, and a wide range of other products. These shippers are all dependent upon rail, meaning that, given the nature of their products and the distances they have to be shipped, they typically don't have competitive options for their shipments. In many cases, in fact, the shipping locations are captive to a single railroad. And in almost all cases, as the comments in this proceeding have detailed, and as you'll hear today, to a painful extent, I hope not, but perhaps, even when there might theoretically be a second rail carrier that can participate in some way in providing some competition, the reality is that for all practical purposes, rail-to-rail competition has simply disappeared. And that's why we're here today. We appreciate that the board in its notice initiating the case seemed to recognize what's become so painfully clear to us, that following the mega mergers of the 90s, and not coincidentally after the expiration of the oversight period of the Conrail split-up, rail-to-rail competition has simply disappeared. Rail rates are rising, service is declining, and there's very little most shippers can do about it. Notwithstanding the good efforts of the board, it's still very, very expensive and time-consuming to bring a rate proceeding. Meanwhile, rail profits are at a record level. They're among the highest of any industry and the top 10% of all industries. They're raising dividends, they're buying back shares, and financial analysts and the railroads themselves are continually pointing to the pricing power of railroads. They have the ability to raise rates and get away with it. It didn't go unnoticed that the railroads were able to raise the rates steadily, even in the face of the worst recession we've had since the Great Depression. In some, circumstances have changed dramatically from the days of the 1980s when the current rail competition policies were established by the ICC. In the 1980s, although railroads were financially healthy, they could still say with some degree of credibility that they were emerging from a period of financial weakness. Today, railroads are the darlings of Wall Street and have more profits than they need to invest in their systems. Again, looking back to the 80s, even if shippers were dependent on rail, they often had some choice of how to combine the railroads that were out there to create some competitive options. In 1980, right after the Staggers Act was passed, there were 39 Class I railroads still. Today, as you know very well, there are 4 mega systems, 2 in the east and 2 in the west, an additional carrier that connects the middle of the country with Canada, and an additional Class I that connects the middle of the country to Mexico. And that is basically it. Despite the changed circumstances, we hear the railroads in this proceeding continuing the same arguments that they have been making for the past 30 years. Their finances are precarious. They have special capital needs. They need to engage in monopoly pricing to earn adequate revenues. And yes, ladies and gentlemen, they argue that they are competing vigorously with each other. I hope the evidence will convince you today that that's not true. You'll hear today from over 24 witnesses from companies, associations, and government entities who will tell you that meaningful rail-rail competition no longer exists. Service and responsiveness are abysmal. Railroads simply do not behave like a competitive industry because they are not one. And in this proceeding, we've been met with a new and somewhat novel argument offered by the Burlington Northern. BN says, wait, we don't need competition because we have regulation. Well, I think we all understand that that gets the policy of 49 U.S.C. 10101 completely backwards. That policy, as Chairman Elliott pointed out in his introduction, says that to the maximum extent possible, competition is to be relied upon to establish reasonable rates, and that regulation is only a backstop. As the board's tentatively suggested in this proceeding, it's time to re-examine our rail competition policies so that indeed competition can be strengthened to the point that, according with the statute, competition rather than regulation can establish and maintain reasonable rates. The board should respond to the vastly changed circumstances we've identified to re-examine and rebalance its rail competition policies. Now, as we've made clear, the intent of the interested parties is not to re-regulate the railroads. Quite the opposite. It's to fully deregulate the railroad industries in the same way that telecommunications and other industries have been successfully deregulated, with not only robust competition, but investment and healthy competitors. In telecom, for example, we've seen a boom in investment, innovation, and revenues that has greatly benefited our country, not just the telecom companies. Frankly, if we were to turn back the clock so that telecom companies were given the same power to monopolize that railroads now have, the public would be outraged. I think, in fact, we would see marches on Washington. So why aren't shippers marching on Washington? Well, it's not that we don't care. It's simply that we've been through these battles for so long that, if I could say, the brick wall erected by your predecessors has been so substantial that we simply got tired of beating our head against that wall. So we're very grateful that you've opened the door in that wall so that we can together look at how we might change policies. Now, I'm not really here today to beat up on the railroads, and I take to heart what all of you have said about being constructive. I simply want to point out that for the last 30 years, we have tended to elevate the revenue adequacy of railroads as our number one policy. And as Chairman Elliott pointed out, the policy of this board has to be directed fundamentally at what is in the public interest, what is in the interest of the people of the United States of America. Our economy, our exports, and the efficiency with which transportation happens in this country depend upon rebalancing our competitive policies. And with that, I'd like to yield to Jeff Moreno, who's co-counsel for the interested parties, who will discuss the board's authority to revisit its policies.
Thank you, Scott, and good morning. As noted by Mr. Stone and by the multitude of comments filed in this proceeding, there has been a significant reduction in competition over the last decade or more, accompanied by significant improvements in the railroad industry's finances. The combination of these changes suggests that now is the appropriate time for the board to review its policies towards enhancing rail competition. My testimony will address the board's authority to modify both its competition and its bottleneck rules in light of these changed circumstances. As a threshold matter, I feel it's important to address the rail industry's distorted mischaracterizations of what most shippers are requesting, and specifically what the interested parties are requesting here. The railroads have framed the issue here as a choice between the status quo or wholesale open access. That is a false choice. The board can alter its competition policies to encourage greater competition that is short of open access, but at the same time is not nearly as strict as the competitive abuse policies that comprise the status quo. In requesting that the board adopt competition-enhancing policies, the interested parties have not advocated complete and total open access, but we've advocated for a degree of access that would restore the balance between the often conflicting rail transportation policies of competition and revenue adequacy. The most direct and effective ways that we believe the board can do this is through modifications to its policies on reciprocal switching and bottleneck rates. With regard to reciprocal switching, the rail industry contends that this board is locked into its existing rules and policies for all time, regardless of any changes that have occurred in the 16 years since ICTA, unless and until the Congress enacts contrary legislation. This argument is absurd on its face. In order for the board to reach that result, it would have to conclude that in ICTA, Congress intended to eliminate the broad discretion that it gave this board in the Staggers Act without actually changing the text of the statute itself. The statute very broadly states that the board, quote, may require rail carriers to enter into reciprocal switching agreements where it finds such agreements to be practicable and in the public interest, or where such agreements are necessary to provide competitive rail service. These are the very words used in the Staggers Act and in ICTA. The term may implies discretion. It's permissive. The alternative standards of practicable and in the public interest, or where necessary to provide competition, competitive rail service, are both broad and undefined terms. And in such circumstances, an agency has broad discretion to define and apply those terms in a way that represents a reasonable accommodation between the conflicting policies that are committed to that agency's care by the statute. The ICC did just that in the mid-tech cases. There, the ICC went beyond the statutorily enumerated standards by superimposing a competitive abuse standards on top of those statutory standards. On appeal, the ICC was affirmed, and the court reiterated this discretion and concluded that the ICC had reached a reasonable decision. The court did not conclude that this was the only possible outcome or decision, but simply that it was a permissible one. It is Hornbook administrative law that agencies may change their policies and reverse prior conclusions so long as they provide a reasonable explanation for such changes. Moreover, an agency's view of what is in the public interest may change, either with or without a change in circumstances, although we contend that there certainly are adequate changes in circumstances in this case, so long as the change is supported by reasoned analysis. This permits the board to modify both its ex parte 445 competitive access rules and its mid-tech decision, so long as that new interpretation is a reasonable reading of the statute, and the board adequately explains the reasons for doing so. The rail industry has blithely ignored this precedent and contends that the passage of ICTA in 1995 somehow carved ex parte 445 and the mid-tech decision into stone. The railroads, however, do not explain how Congress did this without changing a word of the statute itself. If anything, by leaving the statute unchanged, Congress confirmed its intent to leave this matter within the broad discretion that it originally gave the board in the Staggers Act. The board has similar discretion with respect to its outdated bottleneck rules. In the bottleneck decisions, the board superimposed the very same competitive abuse standard on top of the Section 10705 statutory standards for alternative through routes that would short haul an origin carrier. Those decisions, too, were confirmed by a reviewing court on the basis of the board's discretion, but without finding that to be the only permissible interpretation. Thus, the board is not bound by its prior bottleneck decisions if it can rationally explain its changes in light of new circumstances. Nor does the Supreme Court's decision in the Great Northern case preclude bottleneck rate challenges. The Staggers Act was enacted over 45 years after the Great Northern decision as part of a sea change in favor of greater reliance upon competition and much less reliance upon regulation. A bottleneck rule that prevents rail-to-rail competition is inconsistent with that statutory change. Moreover, although the STB relied upon the Great Northern decision as a basis for its bottleneck rule, it's important to note that the reviewing court, in affirming that decision, did not rely upon the Great Northern decision. Rather, it relied upon the board's discretion to interpret the statute. The combination of reduced competition in the rail industry and significantly improved finances constitute changes that would warrant modification of the board's policies on enhanced rail competition. The record in this proceeding is replete with examples of reduced competition. Indeed, I would say that as a consequence of the major mergers since the Staggers Act, there is less rail competition today than there was under Staggers or under ICTA. Consolidation has enabled railroads to exercise greater market power and to engage in consciously parallel decisions not to compete with one another. These facts indicate a strong need to restore competition that has been lost. Dramatic improvements in the rail industry's financial condition also support a policy change. Although the railroads claim that this fact should play no role or have no influence in the board's decisions on this matter, they ignore the fact that this fact was a major issue used by the board to support the current status quo. In Ex parte 445, the board expressly cited revenue adequacy as a justification for the competitive access rules, or rather revenue inadequacy at the time. Similarly, in the bottleneck decisions, the railroads themselves argued that their own revenue adequacy required dismissal of the bottleneck cases. In both cases, the reviewing courts affirmed the agency's discretion on the basis of railroad revenue adequacy objectives. If the board could and did take revenue adequacy into consideration in setting the current status quo between the conflicting rail transportation policies of competition and revenue adequacy, it surely can do so in resetting that balance today. The interested parties seek a balanced approach towards competition enhancing policies. Contrary to the railroad mischaracterizations, we are not pushing for open access. For the past 30 years, the pendulum has swung far to the extreme in favor of revenue adequacy whenever there has been a conflict with the competition policies. We ask the board merely to swing that pendulum back towards the center. Just as the board had discretion to favor revenue adequacy for the past 30 years, it has the discretion to pursue a more balanced approach based upon changes in both the state of rail competition and in the rail industry's financial health. With that, I will yield the remainder of my time to Mr. McBride to discuss the impact of reduced rail competition on the American economy.
Good morning, Mr. Chairman, members of the board. My name is Michael McBride, and I want to address the subject of competition, which has been addressed by so many parties in this proceeding, and I want to see if I can pull it together for you. No one buys rail transportation for the transportation alone. Well, railroads obviously need to be profitable, and shippers who depend on railroads need them to earn an adequate return. The reason railroads were given their franchises to operate was to serve the needs of the public, i.e. their customers. Regulatory policy for most or all of the last 30 years was focused on the financial needs of the railroads. Now it is time to give equal weight to the shippers as Congress intended. The board will no doubt have observed that a very large number of shippers, as well as shipper organizations speaking for many more shippers, have largely told the same factual story. And this is not form letters expressing opinions, Board Member Mulvey, these are facts. That railroads, for the most part, no longer compete and provide neither competitive rates nor the type of service shippers receive from their other vendors. The overwhelming weight of evidence indicates that there is a lack of adequate rail-to-rail competition. What I present here is an overview of the governmental filings supporting the shippers, and of the shipper filings, we provided a more comprehensive summary in Section 5 of our opening comments and Section 3 of the interested parties' reply comments. However, first let me mention what may be the most important point, and that is that the impact that rail rates and practices are having on the ability of railroad customers in this country to produce products to compete with imports, and the ability of railroad customers in this country to compete abroad with exports from other countries is established and is harmful, according to this record. Now, with respect to foreign imports, U.S. railroads do not compete with railroads in other countries, but their customers do. Therefore, when a rail customer is charged an excessive rate, it hurts an American industry's ability to compete with China and other foreign countries and the industries in those countries. Certainly, every dollar by which U.S. industry can reduce its shipping costs is a dollar that goes toward creating American jobs and making American goods more affordable. DuPont and OxyChem, among others, have offered examples of such problems in attempting to compete with imported chemicals because of high U.S. rail rates. Exports from other countries. Northwest Ohio Regional Economic Development Association, on behalf of a metal castings exporter, and Weaver Popcorn, among others, whom you heard in Ex parte 704, have explained the problems that American exporters are having because railroads will not provide rail service from the shipping point, in the case of Weaver, thus requiring the exporter to first ship via truck to Chicago, for Weaver in a weight-restricted container, materially impairing its competitiveness abroad, and similar problems for the metal casting producer. Loss of American jobs. Total provided an example of a situation in which, because of rail rates to a customer in California, they could not produce their product, had to be made abroad, and 300 jobs were lost. Total could not get the railroad to be reasonable. It's often said, these shippers are bigger than the railroads. Why can't they get the railroads to respond? When you're a monopoly, it doesn't matter how big the shipper is. The railroads have the monopoly or the duopoly. The Departments of Transportation and Justice have made an historic filing in this proceeding. We haven't seen much from the Department of Justice since the UPSP merger in this agency, and the Department of Transportation has most of the last 30 years taken the side of the railroads. But this time, those two departments have told you that we shippers should not be required to pay more than is necessary for railroads to earn adequate revenues, that shippers should not pay more than is necessary for efficient service, that shippers should not pay for facilities or services that do not benefit them, and that the responsibility for facilities should be based on demand elasticities of each shipper. And we, of course, do not oppose differential pricing. This is an historic filing. The Department of Agriculture, you have seen on occasion, but the Department of Agriculture has come in far more aggressively for shippers and competition in this proceeding than ever before. Agricultural producers and shippers have continued to express the concerns you've heard for many years about decreased rail-to-rail competition, increasing rail rates, poor rail service, rail capacity constraints, and the fair allocation of rail capacity. And the Department of Agriculture has generally endorsed these comments and also endorses the view we have expressed that there is greater rail market concentration than ever before. The North Carolina Department of Transportation has expressed similar concerns about the lack of rail-to-rail competition and the adverse impact on its ports and its economy. NITLEAG, now I turn to industry groups, has surveyed its members, and most of them do not get contracts that substantially differ from a tariff. The railroads can cancel on 30 days' notice, and the contracts are devoid of any service obligations. The railroads refused even to negotiate, let alone to enter into mutual contract terms. Further, despite rising rail rates, railroads are shifting more of their costs onto their customers to maximize their profits. Today, many more shippers furnish their own rail cars, handle the switching of cars at their plants, and may be responsible for the maintenance of certain rail infrastructure, even providing insurance on it. Now, with respect to commodity groups, coal. Numerous coal shippers have complained, and this is consistent throughout this record, that rail-to-rail competition stopped in about 2003 to 4. At around the same time that capacity constraints occurred and railroads developed substantial market power. All of the rate trend data confirms that circumstances changed substantially about that time. The railroads have cited a few exceptions they claim prove otherwise, but in general, the trends are clear in essentially all cases. When a contract is offered, as I think Board Member Mulvey said, it's take it or leave it. That's what the shippers said, obviously, to you, I know. Moreover, almost universally, the non-bottleneck railroad that has a single line haul will not offer a competitive rate to interchange with the bottleneck railroad. And yet the premise of the bottleneck rate decisions was that the shippers could get such a contract and then would be entitled to a bottleneck rate. It hasn't happened. The rate impacts of all of this are clear. For example, Basin Electric's rate increased over 100%, Dairyland Power's transportation charges increased by 93%, and many other coal shippers' rates have increased by comparable amounts in recent years. Anzo Electric Cooperative in California filed comments subsequent to the filing of our reply comments, saying similar things. In the automobile sector, automobile manufacturers have experienced firsthand the negative competitive effects of Class I railroad consolidation. This is a change in position for the automobile industry if you go back to seeing where they were in the 1980s. But rail rates have risen steadily over the last 5 to 6 years where railroads have reduced their service commitments. Cement. According to the Portland Cement Association, quote, more than 80% of U.S. cement manufacturing plants are captive to a single railroad, unquote. Not only do these captive facilities pay, quote, substantially higher rail rates, unquote, than the competitive plants, but the captive plants, quote, often receive less reliable service. Many shippers of cement and related products are reporting double-digit increases in rail rates far beyond the effects of inflation, unquote. Chemicals, numerous chemical shippers, you'll hear from several of them. Related circumstances similar to the coal shippers. No or little rail-to-rail competition, and even where the plants are served by more than one railroad, there have been substantial rate increases. Crushed stone. Texas Crushed Stone told a similar story and said the railroads would not change their position despite the customer's explanation that business would be lost as a result. Fertilizer. The fertilizer industry filed similar comments. The fact that rail customers who supposedly have competition are facing substantial rate increases is very troubling to the fertilizer industry. Forest Products. Roseburg Forest Products Company filed similar comments, including the important point that so-called Rule 11 rates are being canceled so that shippers cannot get competitive rates. The American Forest and Paper Association filed similar comments in Ex parte 704. Potatoes. The Washington State Potato Commission submitted substantial comments documenting the high rail rates and poor service its producer members get from the railroads, primarily BNSF, which controls most of the rail lines in Washington. In fact, despite the fact that the railroads have a cost advantage over trucks, and despite the clear preference of the potato producers for rail transportation, the producers showed that only 7% of their produce moves by rail, with the rest moving by truck. This contradicts the railroads' oft-repeated public service claims that they are taking goods off the highway and moving them by rail. Paper and paper products. Despite being the largest manufacturer of paper and paper products in the United States, International Paper Company apparently was getting adequate rail service as late as 2009, but cannot get adequate rail service from Norfolk Southern now and filed a petition in docket number 35465 raising its concerns about inadequate service. Popcorn. Weaver Popcorn's president appeared personally in Ex parte number 704 to explain his company's inability to get sufficient rail service to export all of the popcorn largely to China that his company could export with adequate rail service. However, it is losing the battle to Argentina. The reason it can't compete, as I said earlier, is the weight limits on containers for truck transportation to Chicago. NS will not provide rail service from Weaver's plants so that it could use heavier weight containers than the highway weight limit. Steel, AK Steel, in many instances is captive to a single railroad for its transportation requirements, subject to monopoly, rail power, and market-dominant rail pricing, even with the exempt commodities that it ships. And subsequent to the filing of our reply comments, Nucor Yamato Steel filed comments stating that it does not want re-regulation, but rather just needs a level playing field, as it has with all its other vendors. All of these examples make the point crystal clear. Rail rates harm U.S. producers of electricity, grain, chemicals, lumber, and other products, and therefore not only deprive U.S. customers of funds that could be used otherwise to produce jobs throughout the country, but in many cases effectively cause manufacturers to produce their products abroad, costing the U.S. valuable jobs and tax revenues. Well, there are a couple of 100,000 jobs involved in direct employment by the railroads. More indirectly, there are many, and more indirectly, there are many times that many direct and indirect jobs in the industries that depend on the railroads to ship their products. Without your help in providing the balance Congress intended in the Staggers Act and a reasonable opportunity to obtain a regulatory remedy if need be, but only if need be, shippers generally cannot get reasonable rates and service from the railroads. The key point, though, is most shippers do not want a regulatory remedy. They just want the regulatory remedy to be available as a fallback if all else fails. The prospect of commercial success in dealing with the railroads has to be a reasonable one. And with that, Mr. Chairman, I'll stay within the time. Thank you.
Thank you, interested parties, and we'll now hear from the National Industrial Transportation League. You have 5 minutes.
Morning. Chairman Elliott, Vice Chairman Begeman, and Commissioner Mulvey. I am Kurt Warfel, Sourcing Manager for AkzoNobel's North American Operations. I'm here today on behalf of the National Industrial Transportation League, the nation's oldest and largest organization of shippers. Accompanying me is Ms. Karen Booth, the League's General Counsel. The League represents approximately 600 member companies that range from some of the largest to smallest users of the nation's transportation systems. Rail transportation is vitally important for many League members, and especially for those who ship chemicals, petroleum, agricultural, cement, and paper and forest products. Some of our members are captive shippers, operating facilities or shipping to customers that have access to only a single rail carrier. I am very familiar with the rail competition issues that are most important to the League's members, as I have been a member of the League and its rail committee for 25 years. I have also served as chairman of the rail committee from 1998 to 2001, served on the League's board of directors from 1998 to present, and acted as chairman of the League's board of directors from 2006 to 2008. The League applauds the board for its willingness to evaluate the effects of dramatic reductions in rail competition over the past decades, and for considering whether changes to its current policies are needed to increase competitive rail service to sole-serve shippers. As the chairman noted, it is beyond dispute that the railroad industry today looks and operates very differently than it did 25 years ago when the board adopted its competitive access policies. Bankruptcies and mergers have left just 7 Class I railroads, with 4 dominating the industry. This major structural change has provided the railroads with substantial market power over their captive customers and resulted in steadily rising freight rates and mediocre service for many such companies. A survey of League shippers showed our members face rates up to 50% higher at captive facilities than at dual-serve facilities. For a number of reasons, these captive companies cannot readily ship their traffic to other modes of transport. Thus, even during our recent recession, captive shippers were forced to endure rising rail rates despite depressed freight volumes. Year after year rate increases prevent rail-dependent companies from competing effectively against their domestic competitors and thwart efforts to increase exports, negatively impacting job creation in the U.S. Although a shipper may file a rate case at the board in hopes of achieving reduced rates, for most, this is not the preferred solution. Rather, the League believes that rail rates should be established by a competitive marketplace and not by the government. This view mirrors the policies in the Staggers Act to minimize the need for federal regulatory control and to allow to the maximum extent possible competition and the demand for services to establish reasonable rates for transportation by rail. The lack of sufficient competition allows railroads to raise rates unchecked for the most part and to dictate contract terms to their customers. Although many League members use rail contracts, the railroads often are unwilling to engage in meaningful negotiations. Illustrative of their dominant market position, many railroads simply present shippers with take-it-or-leave-it terms. Now, over the past 30 years, the freight rail industry has also transformed itself into one of the most prosperous industries in America, as noted in both the 2010 Senate Commerce Committee's report on the railroad industry and a 2009 Fortune magazine article ranking railroads 5th on their list of most profitable industries. In fact, nothing demonstrates the financial success of the railroads better than the purchase of BNSF Railway by Berkshire Hathaway. This board has asked whether the competition policies created in the mid-1980s are able to effectively address the dramatic losses in rail competition that have occurred in our nation, and whether those policies have swung the pendulum too far in favor of the railroad's need to earn adequate revenues. For the League, the answer is clear. The board's policies have not and cannot function to fulfill the pro-competitive mandates of the Staggers Act. The simple fact is that no shipper has ever obtained competitive access under the board's rules. So what policy changes should the board make? Despite the railroad's attempts to mischaracterize the League's and other shippers' positions, we do not desire radical open access remedies, nor do we desire change that would return the railroads to a state of financial weakness. As rail customers, we understand that the rail carriers need to remain vibrant and healthy and to earn revenues to permit them to reinvest in their networks. The railroads, on the other hand, have distorted the shippers' positions as extreme and presented doomsday scenarios if there is any policy change. The board has asked parties to put aside their rhetoric and to present specific recommendations that will help guide the board in solving today's problems. The League is ready to assist you. We recently surveyed our diverse rail committee members to determine what competition policies are most important to their company and what policies should be changed by the board. They responded that greater access to reciprocal switching and changes to the board's bottleneck rule would help their companies achieve more reliable, efficient, and cost-competitive rail transportation and improve their ability to compete. Changes to reciprocal switching policies were rated as most important. The Lake's captive rail shippers want to increase their access to a second rail carrier while respecting the railroad revenue policies of the Staggers Act. However, given that the board's present competitive access rules have failed to provide any captive shipper with any access to competition, we believe the board should open a proceeding promptly after this hearing for the purpose of developing new, administratively simple reciprocal switching rules that will provide for competitive access where appropriate. The League also supports the other recommendations set forth in its opening comments and the joint comments of interested shipper parties, including that the board should open one or more future proceedings regarding bottleneck rates and merger conditions, among other potential policy changes. The time has come for this board to modify its policies to make them more current, relevant, and responsive to the competitive challenges affecting today's railroad marketplace. The League stands ready to assist you. Thank you for allowing me to provide this testimony and to run a little bit over. On behalf of the League, I'd like to thank you, and I'm happy to answer any questions you have.
Thank you, Mr. Werfel. Thank you, interested parties. I have a couple questions, and I think they're more general questions, so feel free to hop in an orderly manner. First of all, I think one of the themes I've been hearing throughout this proceeding and in the comments and equally so here today in the initial statements by this group is that the railroads haven't been competing. And I guess that's a pretty serious statement, a serious allegation. And do you think, based on the record that we have before us today, that we could make some types of changes to our access policy based on the record before us at the present time?
Certainly, Mr. Chairman, we would advocate opening a proceeding that would re-examine the rules for competitive access. We think that the board can proceed as it wants, but it would make some sense to open one proceeding rather than a sort of a plethora of proceedings. I second what the gentleman from Mid-League said about having a goal of establishing simple rules. When clear guidelines are given, parties know what to expect, and they can negotiate and work out transportation contracts. And we would envision that if the regulatory policy is rebalanced, it will, in a clear way and fairly simple, it would enable the parties to work out competitive transportation contracts without requiring further board intervention.
Thank you.
Mr. Chairman, if I could just add, the Supreme Court has made it crystal clear the regulatory agencies can proceed through rulemaking or through adjudication. And so, for example, you have an oral argument tomorrow, and I'm not going to get into the merits of the proceeding, but it's very interesting in that proceeding that even one of the railroads has taken the position that where an interchange is efficient and reasonably feasible, you have the authority to order it. So I believe you can proceed in both types of proceedings.
Now, with that in mind, if the railroads, I guess, if the allegations are correct that the railroads aren't competing, my understanding, and this comes from various comments by some shipper groups, and I think also somewhat in the railroad comments, that if we do engage in some kind of different access policy that makes that more available to shippers, if the railroads are not competing, would that policy, by opening up the access, be more effective? Would that be effective at all? And I'm hearing some of the shipper groups saying, no, that would not be effective. I don't think I heard that in your comments, but I'd be curious to hear what you thought about that.
I think, Mr. Chairman, that you raise a very good question, and this tension was actually addressed in the interested parties' comments. We are concerned that even if the board does modify its reciprocal switching and bottleneck rules, that there's the possibility that we'll throw a party but no one will come. Our hope is, and I think this will take some time to evolve, is that because the rail industry has become so concentrated, right now it's easy for them not to compete because there's so few places where they are faced with direct competition with one another. However, if you make competition more widely available through greater reciprocal switching, more opportunities for bottleneck rates, the number of opportunities to compete will make it more difficult for the railroads to choose not to. And I would say the rail industry, there are some pockets today where the rail industry competes, but it's certainly not very widespread. And I think if we create more opportunities for that competition, we'll see it will become more widespread. And it may take 3-4 years after your policies are enacted to see the results of that. But I'm very confident that there will be some competition.
If I could simply add, there are going to be instances in which an alternative combination of railroads will be so much more efficient that the potentially competing railroad will say, you know what, I really can offer a much lower rate here, I can get that business. And in contract negotiation with a big customer, the railroad may finally say, you know what, I'm actually going to compete now. Once the competitive dynamic is established, that is, once railroads understand that they may in fact lose business, they're going to be faced with the reality that they're also going to have to compete to gain business. And I agree, it may take a while for this competitive dynamic to kick in, but it will start, and it will be assisted by a change in the policy.
And let me follow up on that. With that in mind, as Mr. Moreno said, if you gave a party and nobody came, what would be your preference if we proceeded down that path of trying to make access and competition more available with the risk that we would result in giving a party and nobody coming, versus taking a look at the regulatory policy that's in place now with respect to making the rate cases more effective? Would there be, if you had to choose between the two, which one would you prefer?
I think undoubtedly most of the shippers in this room would probably prefer to have competition. The very fact that they have to expend resources on pursuing a regulatory remedy means that that's resources and investment they're not making in this country and in other facilities and job growing opportunities. Therefore, I think anyone would say we'd rather let the free market decide this.
And Mr. Chairman, if I may add, I think that's true even of the coal shippers, who tend to be the people who bring the most rate cases before the board, although the chemical shippers have certainly brought several in recent years. Coal shippers want bottleneck rates, I think, more than anything else, so that they can get out there and try to create some competition. May not work, but it's a necessary, if not sufficient, first step.
I'll step up to the plate on this one. Most shippers are going to be very reluctant to file any type of a rate case. I mean, it's going to be a definite last resort, one where you feel that you have closed off pretty much all other avenues. As counsel has noted, it's expensive, it's time-consuming, and it certainly wouldn't do anything to improve your relationship with the carriers that serve you.
Last question that I have, with respect to the present standard with respect to access and anti-competitive conduct. I mean, I know there's been some discussion in these comments about the standard and what's happened in the past, and obviously we've been at this for 25 plus years, really without many results. If you had to set a standard, there's obviously one extreme, which I think you believe is the anti-competitive conduct standard, and then there's the other extreme, which you hear is some kind of open access. Is there a standard that you think would work somewhere in between?
Mr. Chairman, we have to beg off on this question for a very simple reason. We represent a broad coalition, and the members of the coalition have different ideas. We actually decided by necessity, that we couldn't offer as a group a specific proposal, but I think you've heard in the comments a number of sensible ideas, and these ideas, in our view, should be debated in a further proceeding, and I'm sure you will get a number of ideas and more academic comment on various ideas as well.
Thank you.
Mr. Chairman, on behalf of the League, we very much believe that a middle ground standard can be developed. And I can tell you that our organization is working right now to try and develop something that we hope we can bring before this board very soon. We're not in a position to unveil that here today, but we absolutely think it can be done. And we look forward to having that productive dialogue with you in the very near future.
Thank you. We appreciate that.
Just want to add, Mr. Chairman, that no shipper supports, so far as I know, with perhaps one or two exceptions, the board's current policy. No shipper, as far as I know, not a single one, has endorsed open access in this proceeding, and that leaves you in the middle, and I think the statute does provide some guidance on that in 10705.
Thank you. Vice Chairman?
My first question for you is, are you basically talking about the Class 1s, or are you also talking about the short lines in your testimony?
Let me speak to that first because I spoke about the facts and lack of competition. It's overwhelmingly a problem with the Class 1s. There is evidence in this record of Class 2s and 3s competing more extensively than the Class 1s, although when a Class 2 becomes part of a Class 1, then you start to run into a problem. But we have certainly circumstances in which at least the shorter railroads have indicated a willingness to compete. And as Mr. Marino said, we're not trying to prove that 100% of the time in all 50 states the railroads refuse to compete. There are pockets of competition. Certainly in the area of intermodal transportation, there seems as if there's been some vigorous competition, at least for much of the last 30 years. But in most areas, we see the Class 1s have figured out how not to compete with each other, quite frankly.
And by not competing, do you mean they're not offering you a competitive lower rate than the guy down the street?
Sometimes they don't even offer a rate. And when they do offer a rate, it's so unreasonable, there's no point in continuing the conversation. And that's a product of the last several years. Until 2003 or so, I can tell you that people in places like Chicago, have no shortage of railroads typically, could get competitive rates from the railroads. After 2003 or 4, the railroads didn't have to do that anymore. They didn't have enough capacity to go around for things like coal, and therefore, for the most part, they did not. Union Pacific's offered some specific examples. I won't go into the details because they're redacted, but under protective order. But those few exceptions, I think, don't disprove the rule.
What I find interesting about your comment about 2003 or 2004, that things changed, probably half of you in the room were trying to come before Congress or the board to make changes because things were not satisfactory to you, or a lot of this is very repetitive, and I don't mean that in a derogatory way, but you weren't satisfied, happy with the way that things were before 2003 or 2004. I guess, were they legitimate complaints, or did things just completely change in 2003 and 4?
I've been around this for 35 years. I was a young lawyer who worked on the Staggers Act, so I think I can speak to the entire history of it. And I will tell you that the shippers were not all on the same page before 2003 and 4, as I've alluded to a bit in my opening remarks. There were industries that had the benefit of more competition in the past, and so you didn't see the kind of unity back in the 80s and the 90s that you're seeing today, as reflected in our comments. There were huge problems in the 80s and the 90s and early 2000s, but they tended to be for the people who were the classically captive shippers, coal, chemicals, and grain, and some of the other industries. What's happened is that the rest of the industries, the rest of industrial America, has now experienced the same problems. The Knit League members, the automotive industry, potatoes, and on and on. And so what's happened is there's been a structural change in this industry. and it just kept getting repetitively worse and worse. And we all tried to warn the ICC and the board in the BNSF merger and the UPSB merger and the Conrail acquisition. This is going to happen. We're not going to see competition. Trackage rights over thousands of miles are not going to work. The tenant can't compete with the landlord railroad. I don't know how many times I said that. And the board said, oh, it'll all be fine. And then in 2001, the board adopted merger guidelines that said, well, I guess it didn't work out so well. So now we're going to change the merger guidelines. But that was locking the barn door after the cows had gone. And then the railroads took advantage of the situation that they had been presented with in those mergers as approved by the board. You have the authority to do something about that, but that's what happened in a nutshell. It was bad, it's gotten worse. And now we're all in it together.
One of your proposals of reciprocal switching, what would the impact be on rail operations? And of course, I will ask the next panel that as well, but, you know, and what are you willing to pay for the switch?
I think it's telling that even in the Christensen report that was prepared for the board, reciprocal switching was identified as probably having the greatest benefit with the least cost to the rail industry. And therefore, that provides an opportunity to enhance competition with the least risk from the board's perspective on this issue. As far as the pricing, we put in testimony from Dr. Economides suggesting that pricing on a bottleneck segment, which is what a reciprocal switch essentially is, should be cost-based. And I think the board can conduct a proceeding to ascertain that.
Yeah, the cost-based standard was adopted by the FCC, for example, in response, interestingly, to Dr. Willig's testimony in favor of a cost-based standard, in addition to Dr. Economides' testimony at that time before the FCC. What exactly the costs are that should be included, I think that's going to be one of the subjects for debate in the additional proceeding. But you know, the railroads are not going to get a paltry amount. They're going to be able to recover all the costs of that.
Vice Chairman Begeman, I'm sorry, Mike. Yeah, on your point of impact, I think that everyone can also look to the north in Canada and see another country that has a system of interswitching rules that is certainly much simpler and allows for almost automatic access as long as certain conditions are met within a distance of a terminal. And we see the CP and the CN doing just fine in terms of the impact on their profitability and their revenues. And so our view is competition will be good for the railroads just as it will be good for the shippers.
And Madam Vice Chairman, I just want to add something you may or may not be aware of, and that is when the railroads themselves have agreed to grant trackage rights to one another to resolve their differences leading up to or in the mergers and acquisitions. For example, in UPSB and in Conrail, they used cost-based terminal trackage rights, access rights, as the solution. They don't have to come here and have you set a rate. It was 29 cents in Conrail per car mile, for example. I think it was 34 cents in UPSB. That's how they do it. And it's something similar that we think would work very effectively without you having to have hundreds or thousands of these kinds of disputes.
Well, again, besides the cost of it, really the impact on operations and, you know, an efficient and effective transportation system, I really will want to hear from the operators as to at least what their thoughts are on it. I think I'll stop for now.
Thank you. Commissioner Mulvey?
Thank you. I want to turn to this issue of profitability. A lot of ways in which to define profitability, and economists have their way, others seem to have somewhat unique ways. And I was interested in the testimony from Mr. Stone that railroads are in the top 10% of all industries. And this sort of runs counter to the board's finding that I believe as late as 2009, again, we found that none of the railroads actually achieved revenue adequacy when you took into account the cost of capital, both equity and borrowed capital. We have made changes in the way in which we calculate the cost of equity capital. At the suggestion of the Western Coal Traffic Leagues and others, we've adopted a capital asset pricing model. We have now since included a multi-stage discounted cash flow model to try and get an accurate measure of the cost of capital. The railroads also complain that, in fact, our measure of railroad profitability does not fully account for the cost of replacing the capital stock as it wears out. They would prefer that we valued we use replacement cost in valuing the capital assets of the railroads, which would reduce their profits even further. I think one of the things that sort of bothered me a little bit about all the testimonies I received, and I alluded to this in my opening remarks, that there's a shortage of analysis in these, and I would like to get more analytical input to help the board make decisions. And I'd like to throw out to the how do you reconcile the board's finding that the railroads do not earn their cost of capital with these findings reported in Fortune magazine? And I work on the Hill, so I'll stick to the ones. I'm looking for objective analytical studies that show that the railroads are in fact relatively that profitable, and not just for a single year. I mean, that was a recession year, but in the last 4 or 5 years, the railroads have made very good profits.
Commissioner Mulvey, I'd simply point you to the Senate Commerce Committee.
I said I wanted the Fortune 500 article or something in the academic literature that does an analysis. I've read very carefully the Senate Commerce Committee. I work for the Hill, as you know, and I'm looking for something that is reflective of academic analysis and numbers.
Well, I can't really add to the academic analysis, but certainly the reality has been that the railroads have not had difficulty raising capital on Wall Street. People have pointed to the Warren Buffett acquisition and so forth. I would point out one comment that Mr. Buffett made. He was not buying Burlington Northern because it was an entity that could charge monopoly profits. He compared it to the utilities that he already owned. That is, they would make steady profits. They were regulated to some degree, like electric utilities, and the traffic wasn't going to go away. There was really no other way you could ship coal, no other way you could ship chemicals. And with his faith in the growth of the American economy, he just found that this is a company that is going to continue to be profitable year in, year out.
And Mr. Buffett, I believe, said he was investing in America, not simply a particular industry, that he believed that the railroads were critical to the long-term success of America.
And you know, I think everybody who's spoken so far shares that perspective. We're looking to increase economic efficiency. We're looking to promote the growth of the United States economy for the benefit of everyone, railroads, shippers, and the public.
Commissioner Mulvey,
Yeah.
There is an analytical study in the record. 14 years ago, Alfred Kahn provided this to me and said, make use of it when you need it. And it's attachment A to the initial comments of Westlake Chemical Corporation. And he suggests market-to-book ratios. He concluded that the board standards were unworkable, and it's not because of the cost of capital. You labored hard to try to get that right, and that's perhaps beyond the ability of mere mortals to get exactly right. So let's assume you got that as close to right as you can get it. The problem is not in the cost of capital. The problem is in the denominator, in the return on investment calculation. And both Professor Kahn and Professor Jerry Haas, who used to be at FERC, now at Cornell, who provided a backup report to Professor Kahn's statement, explained that with merger premiums, with double counting of assets when the accounting standards changed, and with a variety of other problems, the board's revenue adequacy standard, the return on investment standard, is not workable. The Wall Street standard is average earnings growth and return on equity. Equity is easily ascertainable. So I suggest to you there is the analytical work available to you if need be to proceed on this. And I hope we finally have a level playing field for that analysis. Thank you.
Thank you. Any other comments on that one? The other thing I was raised was also the effect of railroad rates, whether unreasonable or not, on our ability to compete in world markets. The railroads charge that many of these concerns about railroad rates are overstated because the cost of rail transportation is a small fraction of the overall cost of a product. And in fact, of course, it has been America's excellent transportation system that has improved our competitiveness around the world in terms of competing in world markets, even when other countries have lower labor costs or lower resource costs. But our transport network has been so efficient and so effective that it really has made us more competitive. But now we're hearing that these high rates are making us less competitive. Again, I didn't see very much in the presentations showing what percentage of costs rail rates were of total costs and how that translated itself into higher product costs worldwide, causing us to lose market share and for businesses to move overseas. Does anyone give some examples of that they might have, Mr. McBride?
I did give you some in the opening, and I did note the fact you're going to hear from several chemical companies, but let me just give you one astonishing fact. You might want to come back to this when you hear from them. I'm told that rail rates are now more than 50% of the total cost of producing chlorine in many markets. And even where lesser percentages are involved, as I indicated with respect to the DuPont situation, the OxyChem situation, the Total situation, rail rates either are or could have been determinative. But if DuPont hadn't come to the board for relief and OxyChem was its customer, then apparently there was a resolution there that didn't necessitate a board's merits ruling, but DuPont presented you with affidavits, as did OxyChem, of the problem. And Total's comments here present the problem of loss of production in California simply because of rail rates. So this has now become a very substantial factor. And one final point. It used to be that the chemical companies told me that natural gas was the single biggest determinant on their cost. It's no longer, because natural gas prices have declined so much. And rail rates are now often the single most important factor in whether they can compete.
And the railroads made that very point about the importance of natural gas prices. But it is true that with the development of domestic natural gas supplies in the last few years, that seems to have changed.
Yeah. I don't think there's any dispute about that. But what they don't go on to say is what I then said, which is, and now therefore rail rates become the most important factor.
Mr. Mulvey, I don't have much to add on the quantitative analysis, but just as a conceptual matter, I think it's been alluded to in part, but let me just state more expressly. If you look at what the leading export industrial sectors in the United States are, they might change a bit from year to year, but typically chemicals is one or two. Coal is up there in the list. Agricultural commodities, often one or two. This is the freight that bears some of the highest rates of any industry group in the United States. They're the ones who are trying to export. The freight that tends to bear the lowest rates are the manufactured products from abroad. So, at the same time, we're sort of hurting domestic manufacturers in a sense by giving lower rates to that traffic. We understand it's competitive. We're not arguing that intermodal traffic should not have the rates that it does because of competition. And we're in a sense penalizing the main export sectors of the United States economy.
I can give you a little bit of a real-life example, too. My employer, one of our business units, all of the capital that has been expended for capacity enhancements has been in Canada for about the last 5 to 10 years simply because of the competitive rail situation up there.
One final question sort of gets to this argument of primum non nocere, and that is first do no harm. Some of the suggestions or recommendations would result in relatively draconian changes in the board's policies towards reciprocal switching, open access in general, etc. And if the board was to make a major policy change regarding access, would you support doing so on a trial basis so that the board could gauge the impact on the railroad industry? Say, for example, put new rules into place which might sunset in 5 years or so we could go back and see whether or not these changes have done the damage that the railroads suggest they might do, or in fact have improved competition, lowered rates, but the railroads were still revenue adequate. Would you care to opine on that?
Commissioner Mulvey, I think your time frame, 5 years, is about what we have in mind in terms of seeing whether this works or not. Will a competitive dynamic kick in? I guess the one thing I would take issue with, the railroads are quite able to bring to the attention of the board if something's not working. I'm not sure you need to build in an express sunset provision at the outset. Rather, adopt a policy. I think what you're going to see is not a draconian change. But as I said, assuming there are clear guidelines that people can look at and know what to expect, people are not going to be flocking into proceedings. They're simply going to be sitting down at the negotiating table, aware of the changed regulatory environment, and they will work out policies. You may hear very little from your end. You'll hear some. Yeah, there will be some proceedings, no doubt. But again, a 5-year time frame is probably reasonable in terms of seeing how the competitive dynamics work out and what the effects on the parties are.
2 quick comments. First, remember that the Christensen report indicated that reciprocal switching would likely have the least financial impact on the carrier, so that would be a good place to start. And with respect to bottleneck rates, there's a great irony in how the board's regulated for the last 25 years. The statute says that you shall consider whether the railroads are earning adequate revenues when you set rates, and yet standalone cost has nothing to do with revenue adequacy. And you've actually prescribed a SAC rate, for example, in a BNSF case involving Omaha Public Power District shortly after the standard was adopted, despite the fact that the BN at that time was revenue inadequate. So I suggest to you that if you required the quoting of bottleneck rates and moved toward a different standard and the railroad's revenues were impacted, you can adjust the prescription to take that into account. Just as in the basin case, you used 240%. And in the small shipment cases, the 3 benchmark cases, you set revenue variable cost ratios that are indicative of the other traffic on the railroad. So I think the board has the flexibility in setting rates to take revenue adequacy into account. And I submit the statute requires you to do that.
Thank you. I'll now bring up the next panel. We appreciate your comments and your responses.
Nice job. Good. Ed, why don't you sit? Well, how are they going to do it? You want to sit in the middle here? Want me to sit in the middle? Yeah. I was hoping to sit on the end myself. Good morning. Good morning. Yeah, well, I'll sit down. See, we should have practiced this yesterday, gentlemen. Almost. Yeah. I'll be over here. Yeah. I'm over here. Hope this doesn't count against our time, Mr. Chairman.
You're good so far. Is there anybody left over there at the AR?
You're out of time, Ed. That's it. So.
Yeah. Why don't you sit next to it? That's me. Yeah.
Thank you.
Thank God we have names. Yep. Thanks.
We'll now hear from Panel 3, the Association of American Railroads. You have 40 minutes.
Mr. Chairman, thank you. Vice Chair Begman, pleased to be here before you for the first time. Commissioner Mulvey, good to see you again as well. The AR is pleased to have the opportunity to present its members' views on the board's rail competition rules and the board's responsibilities in carrying out its statutory obligation in the context of those rules. To offer a perspective at the outset, there are 4 fundamental considerations that we believe the board must keep in mind as it evaluates the comments and testimony in this proceeding. First and foremost, today's balanced regulations work. They work for the railroads and they work for our customers. After decades of decline attributable in large measure to overregulation for much of the 20th century, America's freight railroads today connect American businesses to the global market, support millions of jobs across the country, and deliver the goods consumers want and need. We have succeeded in achieving enviable productivity gains and solid economic growth in an era of decreased regulation. The country's rail system is second to none in the world because today's regulatory framework supports the private investment freight railroads make each and every year to meet customer expectations to help keep the economy running. Since the passage of Staggers in 1980, freight railroads have invested $480 billion in private funds to grow and modernize this country's rail network. That's more than 40 cents out of every dollar in CapEx and maintenance, and we do it, not the U.S. taxpayers. President Obama recently called on U.S. companies, quote, to get off the sidelines and invest. I was there at the speech at the chamber. It was a great call for investment in infrastructure. It was one of the areas he particularly stressed. Well, last year alone, during the worst recession in decades, the Class 1 railroads invested nearly $10 billion in CapEx. And in 2011, they announced intention to invest another $12 billion in CapEx. We're not sitting back and waiting until the economy is fully recovered. We are already on the playing field today, planning and building for tomorrow. These private investments must continue in the face of customer demand for more capacity and more service. In fact, the administration's draft National Rail Plan recognizes the public benefits when more freight is moved by rail. Less fuel is consumed, less pollution released, less congestion on the nation's highways, and fewer public dollars needed to maintain and build highways. Forced access will reduce railroad revenues. That will, in turn, severely harm our ability to reinvest. And without these private investments, customers cannot grow their businesses and support new jobs. Our nation can ill afford this scenario, particularly as our fragile economy looks to recover. We need to preserve those regulations that encourage private investment and, in turn, allow us to meet the needs of our customers, large and small. Secondly, yes, railroads are indeed in better financial condition than they were before 1980, and thank goodness. But even with these improvements, best year on record, the industry is at the median of return on equity and return on invested capital. And as Mr. McBride himself just said, it is return on equity, ROE, that Wall Street looks to. And in ROE, we are at the median, as you will see in Mr. Reinke's statement. In fact, the fact is, let's face it, customers calling for forced access really want lower rates by eliminating differential pricing. But changing the rules for access is not a remedy for rate concerns. The board has today and exercises it. And again, Mr. McBride just commented, DuPont came here and got relief. The board has the authority and exercises it to address customer concerns in individual rate proceedings, or as it has done in reviewing the standards for rate review. There is no basis from the testimony in this proceeding to change the access rules. Third, requiring forced access will significantly affect the level of service and network operations today's freight rail customers have come to expect. Vice Chair Begman, you mentioned that in your questions, and I draw your attention to the comments of Lance Fritz of Union Pacific and Mark Mannion, who will be here before you tomorrow, chief operating officers, and they can go into much more detail than I about how forced access will affect the ability to invest, the ability to achieve economies of density, and the ability to have a free-flowing network that our customers need. Last, there has been no change in the law or congressional policy regarding rail competition. Statutory provisions, as well as attendant congressional policy and guidance to the board, have not changed. The board and its predecessor, the ICC, have followed the direction of Congress with respect to mid-tech, bottleneck, and other decisions regarding competitive access. Congress has not found fault with the agency's approach by directing it to do otherwise. Since the board has appropriately followed congressional policy and that policy has not changed, there is no legal or policy requirement for the board to change its approach to rail competition issues. But beyond that, there is no congressional mandate to change the law or policy. You have before you, in the strongest possible statements from members of Congress in both houses, both parties, that they believe that the type of changes being proposed by some in this proceeding will have severe consequences not only on the railroads, but more importantly on the customers we serve, the employees that work for the railroads, and U.S. exports in global markets. Re-examination of the board's competitive policies is unwarranted and unproductive. The board's current competition rules have contributed to the ongoing rail renaissance, and there is nothing in the law, in congressional policy, in economic theory, or in the testimony in this proceeding which would justify the board taking any further action to consider or to reverse the proper course it has followed to date. And in conclusion, as you have mentioned as well, Mr. Chairman, the changes that some are calling for are not tweaks around the edges. They are clearly systemic changes to the economic model of this industry. And I submit to you that these kinds of fundamental policy changes are more appropriately resolved in Congress and not by an administrative agency. I'll turn it now over to Mr. Burkhart.
Well, good morning, Chairman Elliott and colleagues. Thank you for this opportunity today. I'm not going to repeat my written testimony, but we'll continue the focus on competitive access and the operating issues that come out of that. I believe that forced access puts in jeopardy the many gains that we've seen in the last 30 years. Let me spend a few minutes, first of all, in an area that I've been active in, and that's in investments and operations in Europe. Often, the European model is cited as being very pro-competitive by customers, and in a sense it is. But it's had some very adverse effects that we, as rail operators in Europe, have suffered with. It creates some very inefficient outcomes. First of all, the full cost of infrastructure capital falls on the government, and I don't think that we're ready to do that in the U.S. So European railways don't have that responsibility on them. Operators are essentially using trackage rights, but they have no control over the infrastructure. Because these operators have lost control on all aspects of the point-to-point operations, they have no say over issues such as train lengths and weights and other vital factors that denominate rail efficiency. The result of this is interesting in that freight rates in Europe, measured on charges per net ton mile or any other basis, are far higher than what we experience in North America. This model has failed to achieve what railroads and shippers require, and has resulted in a very small rail market share on a continent that has higher population than North America and should be doing proportionately better in terms of rail volumes. Further, the result has been that railways in Europe are dealing only in unit trains, and the small part of the operations that remain handling single-car shipments, which is, as you know, is very significant in North America, is fading fast because the regulatory infrastructure does not provide good conditions for a network operator, which is what is necessary to handle single cars. Let me spend a minute on the testimony of Dick McDonald, who is a friend and longtime colleague when I was with Chicago and Northwestern Railway. Dick has been representing the coal industry in this proceeding. He and I both worked on CNNW's entry into the Powder River Basin in the mid-'80s. He was planning the infrastructure, the engineering side of it. I was managing the negotiations with Union Pacific, our connecting line, and the train operating plan. I think we did a very good job in a streamlined run-through operation involving two railways. But when I look back at that, we could have done better if it was a single railway. For example, at the interchange point, South Morrill, Nebraska, we provided for repair facilities, a locomotive shop, and other aspects that where railways normally interchange in the traditional manner. So we lost some efficiencies there that I'm assuming Union Pacific, after they later merged with C&NW, has since corrected. There was also duplicate facilities at Council Bluffs, Iowa, where those trains came back onto C&NW. So with some of the open access and competitive changes that are being talked about, there is a loss of operating efficiency. Let me spend then a moment on the capital requirements of the industry. There's going to be an awful lot of discussion of that. As I mentioned, the European capital for infrastructure comes from government. And I don't think our government is in the position to increase their spending on rail infrastructure spending with the other demands that they have. And I don't think we as an industry want to cross that bridge. It's hard to believe the size of the requirements for increasing capacity. In my experience, back in the 70s and in the 80s, we were fighting the ability to maintain rail operations and to maintain the plant that we had. In fact, we were abandoning lines wholesale. And the idea about increasing capacity was an idea that never occurred to us. But today, that has completely changed. And one of the key reasons that it's changed are the changes that have come out of the Staggers Act, now 30 years old. Rail managements today are planning increases in capacity, and this comes at huge cost. We heard earlier testimony about pricing changes in the early 2000 period, 2003, 2004. I think what we find at that time is when the industry ran out of capacity on the main lines. They needed to raise additional capital to improve capacity on the lines, and the market was allowing them to increase their prices because of this constricted capacity. We need to protect that type of outcome, because that's what free markets are all about. Something that's mandated just plain doesn't work. Involuntary prescriptions can cut off capital investment and not allow the large funds to be raised that are necessary to do our job. Let's keep what works in place and try to move forward on a voluntary basis with our customer base. Thank you.
Good morning. My name is Bill Reinke. I'm a partner in the consulting firm of Oliver Wyman. Over the past 40 years, I've been fortunate to assist with the transformation of railroads all over the world, starting as a brakeman in the 1960s on the New Haven Road, which was bankrupt at the time, working later in the industry, restructuring the B&M Railroad, and then as a consultant, setting up the entire structure, for example, the Mexican railroads, restructuring the railroads in Europe. We're now working in Africa and throughout South America. So my comments today are based not just on our U.S. experience, but some experiences over the world. In Europe, I think, as Mr. Burkhardt pointed out, state-owned enterprises maintain the railway infrastructure at considerable public expense. The freight railroads continue, and in fact, they cannot afford to pay really for a good portion of the operating expenses and almost none of the capital expenses. Even in this circumstance, they are facing conditions where the freight rates are, in some cases, 2, 3, 4, and 5 times higher than the rail rates are in the United States. I provided a couple of exhibits this morning. One of them, it just shows part of the reason why we were able to function that way and offer the kind of rate structure that we do in the U.S. Is that we really have tremendous productivity. The work of the railroad industry really over the last 40 years have brought costs pretty much in line with that has resulted in, as measured here, by some work done by the World Bank in some of the lowest freight rates in the world. Now, certainly not on every commodity and every time, but the other interesting thing is that for most of those other countries that are shown on that chart, those are only the freight rates that are paid to the railroad. That doesn't take into consideration or try to adjust for the taxpayer support or the public support that goes into paying for the infrastructure. And in some of my initial reply, I provided some information on what percentage that is. The other astounding thing, and we've brought many of the European and South American railroad executives, regulators, and even in some cases shippers to the U.S. or showed this to them, is the extraordinary set of outputs from the railroad industry that if you look at that top bar, the railroads have faced, since the Staggers Act, a 210% increase in inflation as measured in the Rail Cost Recovery Index. So the dollars they pay for everything they buy have gone up. In spite of this, the operating revenue per ton mile has gone up only 1%, and the operating cost per ton mile has gone down 15%. So the tremendous change in activity in the industry has been plowed back into holding rates now, which have made us much more competitive both for domestic activity as well as for exports, and I think has provided the foundation for for a lot of the changes that have occurred. The other important thing is that there's been a number of comments about poor service. I guess all these things are in the eye of the beholder, but to the rest of the world, the freight service in this country, unlike passenger service, is the leader. It's the absolute pinnacle, and we bring many of the foreign railways. We are now working in Kazakhstan and Russia and South Africa. We brought them all to this country to learn how, while not completely without fault, how the U.S. railroads are able to, on such a consistent basis, produce levels of service that are unexpected and unrivaled almost anywhere in the world. I'd like to do something about the role of private investment in the industry. Investment in railroads is largely supported by the recognition by the capital markets that individual customers on the rail network have differing competitive characteristics, which roll up into the overall value of the network. So when a private investor invests in one of the U.S. railroads, and I provided information just on the size of that from large equity providers, and standing aside for the moment even the debt, they're basically recognizing the value of that franchise just like you would look at the property value of any other assets and any other productive assets in the economy. The changes to that dynamic of what is the value of those of that franchise and the value of those assets would have a huge impact on the interest in investing. And in fact, instability or testing of various types of regulations that could materially affect whether differential pricing could be applied as it is today, recognizing that there are different competitive circumstances, will substantially chill, I believe, the investor's interest. And we work for a large number of people who invest in the railroad industry and their equipment. In fact, it has been the relative stability of the last 30 years, not the nature of the regulation itself, that has brought investment levels up to where they are today. And if you just take a couple of simple back-of-the-envelope metrics, if the actions that you're considering here today were completely successful and moved all freight rates down to 180 to the regulatory threshold, the railroads would lose $5.2 billion of contribution. You can simply I used numbers that are provided by the STB to calculate that based, I think, on 2009. That falls right to the bottom line. Even if you say, well, they're not, that would never happen. That's catastrophic. That assumes competition everywhere. Even if it falls to an average of 210, so the rates above 180, center around 210, they lose $2.6 billion, and there's really no way to recover that. A couple of comments, I think, going back to some of the questions about whether the railroads are profitable and how they stack up against the industry. In my reply comments, I call your attention to some exhibits labeled 2-1 to 2-5, I believe, which basically use public measures of industry performance, where we took some of the companies participating in this hearing, industry standards, and we just plot the railroad's performance using Hoover and Value Line, which are recognized independent companies to show, and the railroads are not, and certainly in the top 10%. You find good ones, and you find some in the middle and some that are below. Just a few remaining comments on the importance of railroads with imports and exports. We've talked a lot about exports, and I think the railroad industry, and I've been involved in many both railroad-related and shipping line-related and port-related activities, provide a foundation for the export base in this country. Our distances are far greater. If you look at coal, in Queensland, the coal is much closer to the ports, and in this country, the coal is sometimes 2, 3, 4, 5 times those distances, particularly Western coal. So for exports, the railroads have done quite a bit. I mentioned they were even willing to invest in a port in the Washington State, and were willing to do that until they shut down. But imports are extremely important also. Most auto parts that fuel American jobs in the auto industry have at least 10%, and some as high as 50% foreign parts content. And all those parts come in containers and railroad cars. If we did not have an efficient system to handle both imports and exports, just as that one example, you could not support that kind of offshore production. My final comments, and they will be addressed, I'm sure, by other people, refer to what are the operating impacts of creating reciprocal switching or access as is being considered. You can almost go back and track to the 1980s the improvement in railroad performance based on the simplification of the system. There were once 500 or 600 intermodal terminals in the country. There were thousands of interchange points, and that consolidation has led to a much more efficient system. Every time you open up another classification choice or sorting choice, you open up the probability of a failure, and you open up an opportunity for service deterioration. One of the things that we provide is the technology that the railroads use. All 6 North American railroads use that technology to put their operating plans together. It's called different things on different railroads. And that plan basically looks to minimize the number of transfer points, because that's the reality of no matter how hard you try, you're going to have a problem. And if you think of airplane travel, if you have a direct connection from Washington, to say, to Los Angeles, and you're on that trip versus Washington or Los Angeles via a hub someplace, your probability of having a misadventure is much greater because you have to make that one stop. And that's essentially the same principle carried out thousands of times, and others who are much closer to the day-to-day costs, I think we'll refer to that. But that has been an advantage that we have focused on as we've taken the U.S. model and taken it to foreign countries. Thank you.
Good morning. I'm an economist. Everybody else is playing economist so far. I'm a card-carrying one. I've been studying regulation policy toward transportation and toward telecommunications for a very long time. So much so that I easily predate Staggers. I know that competition, along with appropriate regulation, thanks to your predecessors and yourselves, since the Staggers Act, have led to absolutely excellent rail industry performance for the public interest, both competition and appropriate regulation. So as a result, I'd like to focus on some of the indications in this record that bear on your views of what is appropriate policy toward both regulation and competition going forward. I'm disturbed because there's some mistaken claims in this record. First of all, about what are signs of monopolization. How do you tell? What are the indicators? First of all, increasing prices are not signs of monopolization. Increasing prices can be an important part of competition when costs are rising and when capacity is tight. And you'll be hearing more about that for the next 2 days, but I just wanted to get that off my chest. Economic testimony for WCTL. Economic testimony asserts that UP and BNSF have not grabbed coal traffic from each other, and the testimony further asserts that that's a sign of collusion. Well, the railroad's testimony already on the record, and you'll hear more about this, I'm sure, shows that this assertion is factually way off base. But what bothers me even more as a matter of economics is that the assertion is surprisingly wrong and needlessly inflammatory. as a matter of policy, and I just wanted you to hear that from me. After all, to say that coal traffic is moving from carrier to carrier neglects totally the fundamental point that matchups in general between suppliers and customers can be efficient and stable under totally highly competitive circumstances, exactly like those that the UP and the BNSF describe, those circumstances that surround their businesses. So it's just bad economics to jump to an inflammatory conclusion like collusion just because traffic patterns are stable. Well, speaking of what is competition and what is not, the most important point I think I can make today, given what I've been hearing, is that involuntary access should not be confused with real competition. And that's because involuntary access, does not bring the benefits that real market forces create for the public interest. 3 reasons I want to highlight. First of all, the involuntary pricing of involuntary access, which is a key part of any such policy, is regulation, not competition. And moreover, it's regulation of prices that has a very strong, maybe even a controlling effect on the regulation of end-to-end pricing, not just the pricing of the bottleneck or the access point or the interchange. It goes right to pricing of end-to-end services. And it does so without the care that regulation of end-to-end prices really needs, and that has been exercised by the board and by its predecessors since the Staggers Act. So it's a way to get in the way of appropriate regulation of end-to-end pricing. Second of all, even the prospect of forced access impedes voluntary negotiations that themselves tend to lead to efficient routing and efficient logistics. Third, involuntary access arrangements undermine the differential pricing that everybody agrees is absolutely essential in this industry, the Ramsey pricing, as we economists like to call it, because the carriers absolutely have to have the ability, and they do exercise it, to undertake differential pricing in order to boost total traffic, in order to have a shot at recovering their costs and providing the funds that they need for appropriate capital investment. So that's why there should be no forced access unless there is a finding of any competitive abuse that stands in the way of efficiency. We shouldn't just go out and prescribe all kinds of access arrangements of any kind without a showing that there is a competitive problem for which that would be a remedy. Telecommunications is different. It has a totally different set of basic circumstances than railroads, and those differences go right to the appropriateness back in '96 and since then to a system of mandated access quite different from the circumstances in our industry here. First of all, in telecoms, total system costs can be covered by cost-based prices for basic network elements in telecom. And this is not true in railroading, but it is true in telecom, and that was the finding of Congress, of the FCC, by me and my co-authors in long testimony, which we proudly put forward on the subjects in telecommunications, different than in railroading. Second, mandated access in telecom was seen, and we now see the good results, as the only way in the time to straighten out retail rates, which were totally infused with long-standing cross-subsidies. That was the situation in telecom, and part of the findings of the FCC and me and my colleagues was that it was hopeless to get rid of those cross-subsidies without cost-based access pricing that would not stand in the way of overall coverage of costs. And of course, here in this industry, in railroading, regulation has had the good sense to stop cross-subsidization rather than fostering it, as had been the case in the history of telecommunications. Meanwhile, in telecoms, I don't know if you follow this history, but I've lived it in my old age, every step of the way toward implementing mandated access in telecom was horribly complex and led to, and still is leading to, endless litigation both before the FCC and in federal courts, with 3 trips to the Supreme Court on those issues over the last 15 years. Even though telecoms are in some ways more propitious to mandated access, it has been a terribly nightmarish process of trying to get it implemented. In this record, we have testimony by Professor Economides, who was also involved in telecom in its time, on the subject of forced rail access. and I hate to say it about a colleague and a friend, is that his testimony does not try to take into account in his policy prescriptions the basics of the rail industry. And so as a result, his conclusions about access here ignore the needs in railroading of differential pricing, cost recovery, and the operational nightmares that come from forced access in railroading. And in contrast, I think the board and its predecessors have succeeded in taking these factors seriously into account and crafted an economically efficient policy posture toward access. And I hope, and it is my view, that we should stay with it. You've done a great job, and we should let it rest where it is. Thank you.
I think we're about to be given the hook.
I think you're getting,
I think we're about to be given the hook.
you're getting the tap on the shoulder.
But you're not off the hook.
And we want you
No.
back to questions. Thank you.
Are you done with your testimony?
No, but I see the chairman's here, and I assume you'd like to give him,
Of course.
Thank you.
Chairman, go ahead. I know they have questions for us, so why don't we?
And this will be quite this panel will be quite a while, so we'll have you step in.
I think that was bad behavior on my part, Mr. Chairman.
That was not. We're permitted here. And thank you, AAR, for being deferential. We appreciate it.
Pouring out their souls, and they suddenly had to get up and they have to listen to me. But I'm not long. Chairman Elliott, Vice Chairman Begeman, and Commissioner Mulvey, I thank you for this opportunity to let me speak to you. And I'm fairly brief, but I try to be sort of clinically logical. For over a quarter century, I've been working to make sure that businesses that ship their goods by American railroads get a fair deal, and that the railroads serve their essential role in getting goods and commodities to their destinations efficiently for the benefit of the consumer and the entire U.S. economy. The Surface Transportation Board and its predecessor, the Interstate Commerce Commission, was created to oversee and regulate the railroad industry to enforce the law and guarantee fairness all around. Frankly, in the past, the board has let us down, if I can be so bold. It's a bit rude, but I have to speak what I have to speak. What it has meant for West Virginia, which obviously is a more difficult state than many in terms of its economics, but I represent it and care about it greatly, is near bankruptcy of steel mills, chemical companies being bullied on prices and service to the point that they have to consider and do consider relocating their facilities overseas. And consumers will have to pay more for their electric rates. There are a lot of specific examples. I won't bore you with a lot of, but I will mention one, which is Ppg Industries, which is a very large. You're going to hear from them tomorrow. And Ppg has a captive facility in Natrium, West Virginia, that last year paid 85% higher rates than its own facility in Louisiana. Pure and simple, this is not competition, in my humble judgment, at work, and it is prejudicing businesses against my state, which I greatly resent because we need every single job we can get. So I'm here to urge you to be scrupulous in your review of the competition in the railroad industry. After this review that is extensive, I encourage you to act boldly where you can. And where you can't, I hope that you will make incremental changes. Sometimes you can't do everything, but you can do some things. But sometimes people think if they can't do everything, they don't do anything. And the first words I heard when I walked in here, I don't know who was saying this, let it stay the same. And those are the words I'm unhappy with. There's nothing wrong with making incremental changes, because not doing anything is not really, to me at least, an option, and to millions and millions of American consumers and businesses. You must regulate for the future of the industry, not continue to solve the railroad industry problems of the past that have already been remedied. Last fall, I held a hearing about the future of our rail policy, at which you testified, Mr. Chairman, to look at the projected needs for both the passenger and the freight rail network. At this hearing, I released a report on the profitability of the railroads. I didn't write the report. It was a regular report. The report shows that the Staggers Act goal of restoring financial stability to the U.S. rail industry has been achieved, and that significant consolidation has occurred so that 4 Class I railroads dominate the industry. When I came here in my first year in the Senate, there were 50 Class I railroads. There are now 4, maybe to become 2. I do not know. In fact, last year, these railroads ranked among the most profitable businesses in the U.S. economy. Unlike other transportation modes, they maintained their high-profile profit margins even during the recent economic turndown. Unusual. With the freight railroad industry entering this new chapter of financial strength, it seems to me that it's not unwise to revisit our national rail policy. I believe that when this proceeding is over and you evaluate the voluminous facts presented by all sides, you will find that one-sided policies whose sole focus is protecting the health of the railroads is outdated as well as unfair, unnecessary as well as unfair. I firmly believe that you will find that we need to restore balance to protect the shippers against the virtual monopoly of the railroads and modernize the STB's rules to reflect the railroad's profitability and the new industry structure. In fact, quite a lot of new structure in the whole American economy. I think it's a new day. In that light, I have 3 priorities for this agency, which I humbly offer. Increasing competition, fixing current laws, rules, and policies to give captive shippers and competitive options as a method to control rates and to improve service. Secondly, improving the regulatory process, making the board more accessible to more shippers, even to those shippers that may not be captive. You may not have something to bring before you, but that they feel that they have an entrance into this extremely powerful board. So that if they do have disputes, they can be resolved timely and cost effectively, and if they don't, they can learn and have a better understanding of how the system operates. And finally, making the STB more robust, giving the board the authority to proactively address industry-wide problems and the resources they need to accomplish that mission. That's not something that's a complaint, that's just something that you like everybody else, you need money. With these changes, the board will be primed to oversee the industry's future. And I believe the industry's future is a very bright one. I'm very clear about that. I'm fully supportive of a healthy, vibrant rail system. Railroads are critical to the success of our nation's economy, to support our transportation network, and to encourage domestic production of goods. But the American economy doesn't work if all industries aren't thriving. Now, that statement may be a little bit broad, but you understand my point. It all has to kind of work together for it to work for anyone. It's really a symbiotic relationship. The nation's manufacturing sector needs the railroads, and the railroads would be out of business without their shippers. But for this relationship to work, it must be fair. Shipper, railroads, industry stakeholders, and most important, American consumers must believe that the system is functioning properly and that the rules are not being blatantly broken or ignored. Now more than ever, in my judgment, the STB's decision have a very, very clear effect in this new economy of ours, which is whirling about. You have a very, very clear effect on our competitiveness and how business makes their decisions about whether to invest in the United States or to go overseas, which is the present trend. I've long believed that legislative reform would be required to exact required fairness from the board in the railroad industry. Senator Hutchinson and I had hoped to give the STB clear new policy direction in a bipartisan piece of legislation that we had introduced. But, to your amazement, the legislative gridlock on the floor of the United States Senate and Congress in general makes this very unlikely in the near term. But I remind you that the STB has also the responsibility, regardless of legislative processes or momentum or lack thereof, to make changes to correct any imbalances in the rail industry. As commissioners, each of you play a very critical role in making this system work. A formidable role. It's extraordinary power in the hands of three people. And you take your jobs very seriously. I know that. And the current law permits you to make significant change to inject competition in the industry and give the shippers rate and service relief that they do, in fact, deserve. Without ignoring history, you must update, I would respectfully suggest, our rail policies for the 21st century and correct the imbalances in the industry. They're there for all to see. The question is that only a few can correct them. Now, I stress this point, that the Congress is not functional right now. Everything is held up. Everything is objected to. Every motion to proceed to the consideration of any piece of legislation is objected to. So I have to face that reality. So I move away from the idea of legislation just a bit because nothing will happen with it, and I have to be realistic about that. That doesn't make me happy, but I have to deal with reality. And so I think that shifts more, in a sense, responsibility to the Surface Transportation Board. So I hope that you will update our rail policies for the 21st century and correct the imbalances in the industry now that the railroads have been brought back to robust financial health. I thank the Chairman, the Commissioner, and the Vice Chairman very much.
Thank you, Chairman Rockefeller, for taking time out of your busy schedule to present your comments to us today. We appreciate it.
Up and out?
You're good.
Okay.
Thanks. And the AAR can come forward.
By my count, we still have 38 minutes left.
Restart. You're done, right?
Yeah. That's not their count, though.
I'm going to say good morning to the chairman when I can see him. Shall I go ahead and start?
Yes.
Good morning, Mr. Chairman in absentia. Vice Chairman Begeman, it's a pleasure to appear before you for the first time, and Commissioner Mulvey. My name is Sam Sipe. I'm outside counsel for the AAR in this proceeding, and this is the first time I've ever had the opportunity to speak immediately following a United States Senator. I hope I will be equal to the task and can address the questions that might be on your mind later on when we get to the question and answer period. I'd actually like to pick up where Senator Rockefeller left off, which was to ask you as a board to revisit transportation policy, in as much as it appears in his view there will not be a legislative change anytime soon. As the chairman indicated in his opening remarks this morning, and in fact he laid it out quite explicitly, there is in fact a guiding rail transportation policy on the books already. And that policy has basically been in place since Staggers. Congress has not seen fit to change it. Unless and until Congress sees fit to change it, I know that your actions will be guided by that broader rail transportation policy because it's part of the statute. Now, that doesn't mean that within the interstices of the policy and on a case-by-case basis, you can't make changes in the way you've done things in the past. But it does mean that the basic lay of the land in terms of rail transportation has been pretty much set in stone by Congress, and unless and until Congress directs you to make policy changes, you're not going to be in a position to make some of the changes that we've heard about here this morning. And one of the most critical components of the policy, as Chairman Elliott himself acknowledged in his opening remarks, is that Congress expressed in Staggers and reiterated a strong intent that the agency intervene in rail markets only to the minimum extent necessary. That hasn't changed. Now, we have something of a debate in this proceeding as to whether what the shippers are contending for would amount to more regulation, re-regulation, or whether it would amount to what they claim is deregulation. And it's hard to answer that question in the abstract because the shippers have not, in fact, put before you concrete proposals about what the changes that they're advocating might entail. But I submit to you the notion that they are advocating a regime of deregulation really doesn't pass the laugh test. In order for the board to change its regulatory policy regarding access, it would have to make decisions about, first of all, what are the new standards that should govern competitive access. We have a coherent standard on the books today. The shippers find it too stringent, but in perhaps the most striking exchange with the last panel this morning, the shippers were unable to respond to Commissioner Mulvey's question about what standard are you advocating for change. If you get reciprocal switching, what's the standard that's going to govern when the board would authorize reciprocal switching? We have not heard a coherent proposal on that issue to date in this proceeding. And I submit that it would be very difficult for this board to propose a change given the record that's been established to date, since there is no conduct-based standard for reciprocal switching that's on the table. If, in fact, the shipper's real position is that reciprocal switching should be available whenever we ask for it, then that's not a standard at all. It may not be carte blanche open access, but it gives the lie to their notion that they're not asking for restructuring, because carte blanche reciprocal switching would absolutely be restructuring. The D.C. Circuit in the Baltimore Gas and Electric case said that what the shippers were asking when they advocated a regime like that in the telecom industry, the D.C. Circuit characterized that as restructuring. And it said there was not the slightest indication that Congress intended to mandate a radical restructuring of the railroad regulatory scheme. Standardless reciprocal switching would amount to such restructuring, and the courts have indicated that that's not going to pass muster. Let me address briefly another suggestion offered this morning by Mr. Moreno, that the board would have discretion to modify the existing bottleneck standard. I believe the chairman alluded to the state of the law on this issue when he said in his opening remarks this morning that the board had previously addressed its leeway to grant the shippers the kind of relief they were seeking in the bottleneck case. And what the board said is that giving the shippers the rate control that they sought would not withstand legal scrutiny, as it would defeat a railroad's right to determine at the outset the rates it will use to respond to requests for through service. Moreover, and this goes to the very heart of what does competition in the rail industry actually mean, the board found that the relief the shippers were seeking back then in the bottleneck case would not encourage competition, but would go further and artificially force competition by impermissibly depriving the bottleneck carriers of their initial rate and route discretion. The board is on record, at least in my view, having read the cases, that real competition arising from market forces, which is what we, the railroads, advocate, is not the same as forced competition of the sort the shippers were asking for back in the bottleneck proceeding. In conclusion, the current competitive access and bottleneck rules have been affirmed by the courts and have been established agency precedent for years. In light of the clear policy and statutory underpinnings of the current rules and lack of any congressional action to replace those policies, there is no legal basis for the board to adopt an expanded program of involuntary access. Thank you.
Thank you, panel. We'll go to Vice Chairman Begeman.
All right. I won't have too many questions, I don't think, but I guess we'll see once we get into it. Mr. Hamburger, I do have to say I do disagree with your comment that this proceeding is unwarranted and
further proceedings is, I believe, what
unwarranted and unproductive.
Further proceedings, right?
All right. I mean, I do think this is a very useful process that we're going through, and I know I'm learning a lot and have a lot more to learn. And thank you, all of you, for helping me do that. Do you care to respond to Mr. Moreno's and Mr. McBride's comments about reciprocal switching and the cost-based approach that they were suggesting? I realize that you didn't even want to get to the concept of whether reciprocal switching could even be changed, but because I want to kind of get a sense of impacts.
I feel compelled to defer to the real economist on the panel, Mr. Willard. Card carrying, if that's okay with you.
Sure.
Thanks. The point I was trying to make, and I was feeling very hurried because
sure people can hear
of timing, but so thank you for bringing it up again. But the point I was trying to make is that when access arrangements are pushed, are mandated, are forced, especially at cost-based pricing, that governs all of the pricing that results in the industry, including end-to-end pricing, the pricing of the entire movement.
So it's a domino effect.
You might call it that, although domino effects are always negative, the way, going back to Vietnam anyway. But in some industries like telecom, where cost-based pricing is okay as an ideal that we think we should strive toward, because cost-based prices will cover total costs, and because in the absence of a regime like regulation or better placed regulation, we're going to have a morass of cross-subsidization as we had in telecoms. In a system like that, the domino effect may not be so bad, even though it's a very costly process in terms of the legalities involved and the operational impediments involved. But in railroading, we can't live with cost-based pricing. We don't want cost-based pricing. We need differential pricing. And everybody understands that. We heard the shippers endorse that. I was delighted to find some point of contact between the first panel and my own understanding, because there's so much in the way of fixed and common costs in the industry. There's so much track which is used by so many different movements and so many different shippers, so many different commodities, we want the railroads to have the ability to cut prices close to variable cost to encourage more traffic, and yet price those shippers who have more value from their rail movements at a level that can help to cover the total cost necessary for the operation. So we have to have pricing that is not slavishly governed by variable costs in railroading for the public interest. And if we push access to be widely available on a course basis at cost-based rates, then we're making it impossible for the industry to undertake the differential pricing, which is vital for the public interest. So from the start, the whole idea of wide open, involuntary, cost-based access pricing is really the wrong approach for this industry, and it's quite a disastrous scenario, I think.
But it works in limited contexts, such as the merger agreements?
Well, maybe as a remedy for a discernible problem, then it might very well make sense. And I think that is the current standard, that if there's a showing of a competitive abuse, which is standing in the way of efficient logistical arrangements, then there ought to be some regulatory remedy for that public interest problem as well as for the shipper involved. And going to then access arrangements that are mandated makes a lot of sense as a remedy, like for a merger problem or for a showing of anti-competitive conduct.
And that doesn't negate the ability to differentially price?
As long as it's narrow,
yes,
and it's in response to a found problem, then it doesn't undermine the entire needed structure of the industry.
Or voluntary. Or voluntary.
Yeah. Well, yeah, that's the other point to make, I think, and thank you, is that we do see lots of voluntary interchange, access, routing arrangements in the industry. You folks probably can speak to that much more factually than I can, but I know that in general, the railroads have just loads and loads of voluntary arrangements that lead to efficient routing, efficient logistics, and pricing that is subject to regulation if there's a competition problem, or that is just a marketplace, market force kind of pricing if there's not a competition problem, and that's part of the efficiencies that the Staggers Act and the history since then have brought about. Voluntary cooperation in routing. That works for efficiency.
Can one of you comment on the Canadian model? And I mean, I'm a little disappointed that none of the Canadian carriers are going to testify before us the next 2 days, but if one of you could kind of, I know they have submitted for the record, the written record, but why can't it work?
I can discuss that, having done business there as well. They call it interswitching rates, and it's based on distances from the interchange location where two railways come together. In kilometers, I believe it goes out as far as 50 kilometers, and there are about 3 or 4 zones, 10, 20, 30. I'm speaking from memory, so I'm not exactly sure where the dividing line is. And that it's a fiat system. The Transport Canada, the regulatory authority, has established a charge applying within Zone 1, Zone 2, Zone 3, and so on, that they update about once a generation. And they're generally seen as loss leaders for the railways that perform the services, although I suppose the railways that are buying the services I think that that's okay. I don't see it as a particularly effective system at all, and as other people on our panel have pointed out, it's a completely a regulated system. I don't know what the basis of their charges are, whether it's something that they actually went through a procedure to determine cost and then implemented that, or whether it was some number that was pulled out of the air. But the charges are very low. They're much too low to cover cost.
Might I throw in I'm sorry.
How does it impact their ability to provide service? Does it?
The railway actually performing the switching services is damaged, and in fact the operation that I'm involved in Canada today has a lot of industry. It's a short line railway that has quite a bit of industry on its line that is accessed by Canadian National. And we lose money on the business moving to or from those points because they're moving on these mandated interswitching rates. So that has weakened our position there considerably. Now, we have no say over those. The pricing that the customer gets, that's all determined by Canadian National, who's taking long-haul movements out of Western Canada and then moving them, and then we move them maybe 25 kilometers over our railway at destination.
If I could make two comments. One, I think the CN and CP have made it clear that this was a policy in Canada as the network was being developed. So it also is a much more linear network than you see here in the United States. And so I think that the operational impacts may not be as great since they have developed with this as a policy. But secondly, just from a policy standpoint, I would observe, and I just was at a conference in Canada a couple of weeks ago, that with this policy in place, the customers in Canada still want further rate reductions, still want further rate regulation. And I think it really underscores my belief and what I said in my opening comment, that this is not about access, this is about setting some sort of cap on rates. If this was the answer, then I would infer that shippers in Canada would be quite happy. And that's not the case.
Just one final comment on this, Vice Chairman Begeman. I spoke earlier about how any significant change in access policy by this board would have to be grounded in statutory change. And in Knit League's comments in this proceeding, their opening comments, they stated that the Canadian switching model could not be adopted wholesale in the United States based on our current statutory structure. So I don't think it is in fact on the table. It would be, if I understand the shipper's position correctly, there would be no conduct-based standard as well. So you go once again from the current situation of a well-defined, albeit stringent standard, to no standard for access.
You don't want to say anything, Mr. Economist?
Oh, ask me another question.
Well, I agree that the issue of the standard has not been addressed, and I'm sort of kind of going to the next step, just based on who I have before me here. Mr. Shipp, you mentioned that there are changes the board can make, has the ability to make in your opening statement, and then you also went into the fact that sort of along the lines of, but yet you can't. What is it that you believe the board cannot do?
Well, I talked about the two things I think the board absolutely cannot do, which I believe at least some of the shippers are pressing for. One is to basically overturn the bottleneck decisions. The second is to adopt an approach to reciprocal switching or prescription of through routes that is essentially standardless and that has the effect of restructuring the industry. Now, in between those extremes, it's really hard to speak to what the board could do because we don't have coherent conduct-based standards on the table. And it's going to be very hard for the board to formulate one based on this record, I think.
One sort of last issue I'd like to touch on, and we've heard a lot about whether it's open access, forced access versus reciprocal switching, bottleneck. What is your definition of what the first panel was recommending? Do you define reciprocal switching and bottleneck as open access?
If it's standardless, yes, it's a form of open access. If anybody who, let's just say, if any line haul carrier that gets to a terminal area in which there are closed industries has the right to serve any industry in that terminal area, then that's a form of open access, at least as to that terminal area.
Yeah, I think in looking at the record and the different filings, this is very similar to what we saw in Europe in the 90s that led up to the European Union 91/440, which was their promulgation of open access. So they may be calling it something different, but without any boundaries, or even with limited boundaries, it will have the effect of open access. Because I don't think it will stop with the first tranche of customers. Because then the next step will say, well, gee, I have two shippers, or two railroads, but I'd like, maybe a third to come across the Mississippi. So it looks very similar to the open access commentary, dialogue, cases that were being offered. And in Europe, they adopted it. I think it was a poor decision, but they adopted it.
Thank you.
Yes, sir.
Thank you, Chairman Elliott. I have a few questions on reciprocal switching also. The Christensen report suggests that of the myriad of competitive policy options that they looked at, that seemed to, in their mind, have the smallest effect on railroad profitability and might be one that is most positive for shippers, presuming that the board has the authority to do something about reciprocal switching. I recognize that they qualified their position in their supporting statement that they filed with the AAR. But nonetheless, it doesn't seem to change the position that if one assumes that reciprocal switching is limited to less than 10% of the total movements or somewhere near the 30-mile proposed limit, the limit proposed by the USDA, why isn't that a reasonable and limited approach for the board to pursue? Mr. Rockefeller talked about incremental change, and if this board was trying to improve the competitive landscape, wouldn't reciprocal switching be probably the least onerous for the railroads to deal with?
It could be the least onerous, Commissioner Mulvey, but least onerous doesn't mean that it's in the public interest by any means. Least onerous may mean, you only lose a pint of blood a day instead of a quart. For me, that's not. I'm not on the road to health.
Of course, the shippers would say that was a loss of a pint of blood. It might be a transfusion, in which case they may feel that they're benefiting from it.
They're certainly looking for a transfusion. There's not much doubt about that.
Well,
let's focus on the public interest dimension of it, though. Yes, I concede reciprocal switching might be less onerous than the other remedies that have been mentioned in this proceeding, but is it in the public interest? Christensen doesn't say that. Absolutely, Christensen doesn't say that. They say the impacts, the adverse impacts, would be the least possibly, but then there are two very important caveats. One, they did not have operational issues on their agenda. They didn't look at the impact of any access remedies on operations. And the testimony in this record of both Mr. Fritz and Mr. Mannion suggests strongly that operational problems stemming from reciprocal switching could be substantial. Second, Christensen made its observation about reciprocal switching within the context of positing a voluntary transaction between two willing parties and positing compensation that would make sense for both those parties. And I'm quite sure that the kind of compensation that the shippers are talking about here, and we actually got to it this morning in the discussion of the cost-based compensation, is not the sort that you'd find in a voluntary transaction.
And reciprocal switching, of course, begins as a voluntary transaction because there was that reciprocity that was presumed. But It is also true that there's been a real decline in the number of stations and shippers open to reciprocal switching, and there's been a substantial decline for some railroads since 2007. CN, for example, has had almost a 60% drop in stations open to reciprocal switching. CSX, who we'll hear from later, has had almost a 50% reduction in stations open to reciprocal switching. This is something of a concern. The availability for reciprocal switching seems to be going down. CP just put out a tariff that announced that any shipper who had not used reciprocal switching, or any station that had not used it in the past year, would be closed. Do you want to comment on that on that policy? And is that a preemptive strike at the board doing something about reciprocal switching?
I personally do not have knowledge of this policy or practice.
We have the data on this, and it is.
I think just a couple of points. One is just maybe taking a half step back to what you were asking before. One thing I don't think the Christensen study does is look at what the revenue impacts of those locations are. If, in fact, differential pricing is being applied as you would think it might, the stations that are asking reciprocal switching is where your higher rated traffic were. So your revenue loss is disproportionate. So it may be 10% of the stations that may be 25% of the revenue, and that's really a critical item because that's what investors really look at. They look at the contribution, the application of Ramsey pricing and differential pricing. Mm-hmm. As far as the reduction in reciprocal switching, the only thing I can say to that is part of some of the operating work that we've had some experience with. If people are not using it, it's like a turnout or a switch. Many railroads are ripping up switches where the shipper hasn't given them a car in 5 years or 4 years because there's a cost basis to that. And if you're not having to gear up to split the traffic through reciprocal switching from an operating standpoint, and you can start focusing on a better service and a better density, it becomes an operating convenience to say it's not being used and let's put it away. I've not seen it used in any competitive way. I've seen it used almost like in the same regard as closing switches. And I just will add something about the Canadian experience. We just worked on a situation up there that had to do with coal. And the interesting thing was, because now the traffic is up for grabs every year back and forth, one of the two railroads had an enormous investment in car shops to repair coal cars and to handle the infrastructure, is now saying, I've lost this 2 years in a row because now I'm getting short-hauled. I only need 70% of those shops. They're making some longer-term structural changes that if, in fact, it does come back, there's going to be a service issue because they don't have the cars and they don't have the shops. So that's one of the reasons why I think shippers in Canada have maybe not used that as much as they could, because flopping back and forth creates huge havoc for the two railroads as to whether or not the traffic is going to show up on my line next year and do I have to gear up to handle it.
But of course, of the two Canadian railroads, at least one of them, they've had reciprocal switching, the mandated reciprocal switching now for a while, and both of those railroads, especially the CN, I believe, is profitable, even though they may not be happy with reciprocal switching as public policy. Is that not true? Is that not true?
I think they're profitable. You'd have to go back and really look, and I haven't seen any research on how much of it is really going on up there. I mean, it does exist. It's on the books, whether it's 2%, 5%.
It would be a relatively small percentage of the total business in Canada that ever gets interswitched. And the charges, part of the problem from the standpoint of the railway performing the switching service, which may actually be a short line, with the guy that's got the 2,000-mile haul then coming in and saying, now I'm going to give you 2 cars of business, and we expect you to haul out 20 miles to an industry, and we're going to pay you $150 a piece for this. You're going to get $300 and run out to that industry. Now, if you got a unit train of coal, and you had 100 cars, and you got $150 a piece, that might work fine. But part of the problem is that in a regulated mandated system, there's no way to make those individual judgments that the market does, where the situation is different between one location and another. the difference there is what service is provided, what volume is being handled, what is and very frankly, what is the value of the commodity, so that the handling carrier can look at differential pricing that are supported in the marketplace, because there is no marketplace then in providing that service.
The other thing I think you could maybe get from the CTA, because I've seen it in hearings that they have, is there's a map that shows how many points on the system are within whatever the distance is, and Canada is a very long and thin country, and the railroads developed essentially in parallel, and not many places that were within whatever it is 25 or 35 kilometers of one another. So if I remember the map that I saw some years ago, it was not a lot of overlap areas where they were even within the zone where it could work.
I think it's widely agreed that any application of reciprocal switching to the American environment could not mirror the Canadian, or would have to be different to take into account the very, very different nature of the railroad network here in the United States. So it was mentioned about that graph came up that we'll see many, many times, the growth in productivity and the lower rates and on and on and on. But isn't it also true that for a long time productivity gains and the railroad set records in productivity gains, both in labor and capital productivity over the last few decades, especially since staggers, and most of those gains were passed on to shippers in terms of lower rates. However, more recently, rates have been rising, and analyses that I believe is coming out, and I believe you're all familiar with, the productivity gains are no longer being passed on to shippers, but are rather being now greater portions of them are being kept by the railroads. And would you want to comment on those findings? And I'm sure you're familiar with them, because one of the authors of them is somebody who is now testifying on behalf of the AAR. Not here, but
just one comment, maybe some others can also contribute to that. I think there was actually an exercise you could do quite handily over the last 25 or 30 years, that you could look at the cost structure of the U.S. railroads, railroad by railroad, and almost estimate what could be done if things were done differently. So you could say, I know how far I can go if I can get the flagman off, get the caboose off. All of these things, would fit together. So during that period of time, if you looked at that graph I put on there, the way that the railroads were able to offset over 200% cost inflation was that they were taking units of input out of the bottom of the system. I think one of the things that's happened, we keep talking about 2003, 2004, is that pool of opportunity has vastly shrunk. I mean, maybe you can go down to one trainman per train, and you can get better efficiency out of some track equipment, but we've squeezed, you're up to 286,000-pound cars, you've got contents. That reservoir of change has declined substantially. So that means that and the inexpensive things were taken care of. That means that for the next steps of productivity change, you've got to spend money, some real money. You've got to build flyovers like you see in Amarillo and in Kansas City, and some of the big complex infrastructure. So the railroads, it wasn't just the case of suddenly capacity got tight, is that they ran out of the cheap productivity things. Now they're in a point where they've got to spend a lot of money to get the same productivity changes they were getting 5 years earlier by just abandoning or cutting back, and they need higher rates to cover that. So that's what I've seen as a big driver of why the rates have gone up, and that's, I think, reflected in that chart that I put up there.
But it also suggests why the productivity gains and the benefits from them are going back to the railroads more than they were in the past, because the railroads are having greater cost outlays to achieve those productivity gains. Is that your...
Exactly, and I also think, and I think as Mr. Burkhart pointed out too, my first 10 years working in the railroad, particularly when I was on the B&M, my job was to abandon half the miles of that little railroad. Mm-hmm. And it was an easy way to get productivity. The more miles you cut out, the higher your average density went up. Those kinds of cheap reductions are gone, and the railroads now found themselves in the early 2000s with having to start planning and building for increased capacity. And you can't add railroad capacity just next year. And that goes into why was there high spending, in my view, during the downturn. The railroads didn't cut their capital spending back like the rest of the industries, because they see that coming out of the recession, there's 2, 5, 6-year, 10-year capital spending programs that we've got to run up our investment in infrastructure, or we're not going to be able to catch up. We can't do it in 2013 or 14 if, in fact, traffic comes back. We've got to do it in 2008. So I think that's partially I can't explain everything. That's what was going on during that period.
Would you also say it's part of concomitants with the fact that a lot of legacy contracts were there and railroads couldn't raise rates, although after staggers, the railroads went from 100% tariff-based rates to, I think, 95% contract rates, and many of those contracts were long-term and rates couldn't be raised, and so that was one of the reasons why productivity improvements were passed on to the shippers, because you couldn't raise rates, and you still want to make the railroad more efficient.
Yeah, the legacy rates carried some of the revenue through the recession, and also many of them kept the railroads from charging fuel surcharges. So
yes,
so there was.
We had the hearing on that.
Yeah.
Mr. Muller, I got one question for you. We talked about the involuntary access issue, and as an economist, one of the complaints that's raised by shippers is that railroads, as duopolists in the east and in the west, collude. That is, as game theory would suggest, with the fewer competitors you have, the easier it is for the players involved to begin to figure out what the other one is going to do and then behave accordingly, because I know if I do this here, you're going to do that there. So there's this agreement. I am not going to compete with you here, and in so doing, you will not compete with me there. And that there's this argument that you don't really have price leadership or followership. What we really have is almost price collusion on the part of the railroads. Would you want to address those arguments that the shippers have often made?
Yes, thank you. I was trying to talk about it in somewhat circumscribed terms during my 8 minutes, because I just found it extraordinary that the testimony by the economists and also by the direct representatives of the Western Coal Traffic League were jumping to the conclusion in testimony of collusion as a conclusion from evidence that, well, prices were going up for the coal shippers. And as we've been talking about all day, there's lots of good pro-competitive reasons why prices sometimes go up, as well as, in our record, frequently go down, but also directing themselves to a conclusion of collusion based on the fact that traffic wasn't changing, coal traffic, from one carrier to the next, and saying that that's a sign of collusion, which I expressed as inflammatory or conclusory, but kind of troublesome as a bottom line, because it makes sense that after a while, when competition has worked itself out, the market will find efficient matchups between the abilities of a transportation carrier and the needs of a customer. And even if the traffic jumps back and forth for a while, it's likely to settle down into its most efficient set of logistics, as long as the basic circumstances aren't changing radically from year to year. And that seems to be totally off the table as far as the commentary that stable matchups, they say, is a sign of collusion, when it's just as much equally likely to be a sign of efficient arrangements stabilizing in a competitive environment.
An equilibrium solution, so to speak, yeah.
Perfectly well said.
I know that you're an advocate of contestability theory, but contestability theory is also predicated on the assumption of low barriers to entry. And clearly, in many cases, we don't have low barriers to entry here. I mean, obviously, singly, to use Mr. Hamburger's term, singly served shippers, or to use another term, captive shippers, don't really have competitive access. And in order for a market to be contestable, then another railroad would have to have access. Would you want to comment on the applicability of the contestability theory solution, easy for me to say, in the railroad case?
Sure, I'd love to. Thank you. The first thing to say is that railroads are not a perfectly contestable market. Far from it. Because one doesn't just go out and build a new railroad to access a shipper, even though there may seem to be a business opportunity there. You're talking about a 40-year commitment, huge sunk costs, fixed costs, geographical issues, permitting. This is not easy entry to build new rail facilities in response even to market need. But that's not to say that there aren't other forms of fluid competition in the industry. For example, where the trucks go is certainly highly contestable. And if trucks can go and pick up a load and then bring it to a rail interchange, that's a form of contestability without there being the ability to build brand new rail assets. Just redirecting the trucks is quite a contestable part of the market. or likewise a utility plant that decides with some cost to change its source of coal. And so they go from one mine to another mine, which means going from one railroad to another railroad as a serving entity. That also can be quite fluid as a form of contestability or competition without building brand new rail facilities. But with all that said, there's going to be situations in the industry where there are captive shippers. And that's why you've got the right kind of regulation that you have. And that's why it was so smart for the ICC and in a continuing way by the board at some level of principle to say that, yeah, contestable markets, we're trying to stimulate through appropriate regulation the discipline on pricing that a truly contestable market would bring. Because nobody thinks that this is an Adam Smith-like industry, but as a guidepost for regulation, contestable markets makes a lot of sense. It fits. And that's the way rate regulation has attempted to be configured, but with alterations for practicality, which is understandable.
Just one more question, and that is to Mr. Hamburger. You mentioned about the $400+ billion the railroads have invested in the last few years, and we recognize, too, that the vast majority of that is simply to replace capital as it wears out, as opposed to being expansion capital. And I think Mr. McBride pointed out that the railroads, the advertisements the railroads have is that they can carry so many trucks and take so many trucks off the road and much more efficient, much lower fuel, much better fuel economy, et cetera. But the reality is that much of the traffic growth is really in the non-truck competitive areas. The industry seems to be focusing on coal, on grain, on chemicals, and the like, as opposed to really taking the trucks off the road, and that we see both railroads and trucks both increasing, and much of the increase in the rail market share can be traced to the decline in water carriage and movement by the minor modes. Would you want to comment on that? Are the railroads actually going to begin taking trucks off the roads as we see them, or is it simply going to be the growth of coal traffic and grain traffic and the like?
I'm sorry that Mr. Lanigan of BNSF will have to wait till tomorrow to answer that question. Being a former trucker and Chief Marketing Officer of BNSF, I see he's here, and I'm sure he'll give a much more eloquent response. But I think I disagree with your basic premise. The fastest growing market share, the fastest growing sector of business is intermodal. In fact, if it were not for export coal, I think coal would be down right now. And that the intermodal is what is growing at 5, 6, 7%. Everything else is below that. And so I think the focus that I see with the $200-300 million per copy are railroads investing in intermodal yards, railroads cooperating with ports, trying to see how to make sure that both export containers and containers imported can be moved effectively. So I disagree with your premise that the focus is on bulk commodities alone. Obviously, that is a focus as well, but I think the truck competitive piece of the market is where a lot of the growth is actually occurring.
I agree. The intermodals, I should have added that. I was more concerned about the onesies and twosies, the small merchandise traffic shippers where you only have a handful of cars. That's truck traffic, is going more to truck traffic also. And I know that some people, like Charlie Marshall, for example, believes that's where the railroad's future actually is getting back to merchandise traffic. I
would like to weigh in on that because this is one of my favorite subjects. Because I mean, we've all read about is the boxcar debt and all that type of thinking, and in fact, the place that's doing the best job in the rail industry today with that type of traffic, onesies and twosies, is the short line and regional railroads, and generally they get cooperation from their connecting class ones. Sometimes you have to pound the table a little bit to get their attention when they've got lots of intermodal trains, coal trains, and all of that in the picture. But overall, it's very much in the interest of the class ones to cooperate with their smaller connections in developing that traffic. And if you present it right, and if it's priced right, you can do it. today's increases in truck costs largely because of fuel and some other things related to the economy, driver shortages, we're starting to hear about that again. This has helped rail competitiveness. And I think a really well-managed Class 1, and most of them are, will take that opportunity.
Thank you, Dan.
And while it's not a onesie or twosie, I would draw attention to the board, I'm sure you've seen it, that while UPS has been our single largest customer for some time, FedEx has been reluctant to use rail. They have just earlier this year announced, I think, with all the Class 1s, a major partnership to get trucks off the road and move their long-distance shipments by rail. So I think that speaks to the fact that that's what we are doing, and the reason that is possible, in my opinion, is because, getting back to our theme, the investment makes it truck competitive. If you don't have the service, it doesn't matter what the price is. You're not going to get a FedEx or UPS. So the investment is there so that the service is there so we can get the trucks off the road. And FedEx has just tumbled to that conclusion as well. So,
Thank you.
Thank you, Commissioner Mulvey, our card-carrying economist. I just have a few questions today. Most of my questions, I think, have been answered in this lengthy discussion, and I do appreciate you stepping aside for a moment for the chairman. First of all, this is what the other chairman. First, this is what I really struggle with here. I guess maybe one of the big reasons why we're here. 26 years ago, the ICC came out with MidTech, and they issued a standard of anti-competitive conduct. And from what I can see over the period since that time, we really haven't had a case since. So it appears that something is not working. I know that the railroads, maybe you don't think something's not working, but it appears that something's not working. I find it hard to believe that, and this is not any slight on your behavior, but that behavior was perfect throughout that entire time. So my question being is, what would cause anti-competitive conduct under that standard? Is there something that you can, I think, and I see your card-carrying economist nodding, that there is an answer to that question, but I think probably what I hear from the shippers is there isn't an answer to that question, so I'd be curious to hear what your answer is.
I was just jumping up and down as you were speaking because my first impression is that, and this is based on the logic of the situation, that when the right standard is put forward, a good result is that the standard is not needed because it provides the right incentives to the marketplace to solve access issues in a voluntary and efficient way that harnesses market forces. So the fact that there aren't bevies of complaints that meet the standard, I would take, as a matter of logic, as a really good sign rather than as a bad sign, as your remarks were suggesting. When the parties know that they have recourse, when the shippers know they have recourse, when the carriers know that the shippers have recourse to a proceeding based on the abuse standard, they're very highly motivated not to abuse and to make a deal which ordinarily would make economic sense if there is an efficient interconnection, an efficient use of switching, an efficient routing which is not already on the table. There's already good economic incentives to make it happen. It's win-win for the shipper and for the interconnecting carriers. And if in addition there's a standard that's well-tuned, as yours presently is, that's just icing on the cake, a further cementing, to change the metaphor, icing and cement, to very strong incentives backed up by the legal environment. So I would take it as a good sign, not as a bad sign. Counsel?
Sure, there's no reason why a shipper wanting to move a carload between any 2 points in North America can't get the interest and the pricing out of the railroads involved. Now, will that pricing be always what he wants? Well, this is the nature of the competitive economy. Often it won't be. If it's too high relative to the road, the railway is wasting their time, and they might as well plan to get out of business because the road's going to take the traffic. So an intelligent railway is going to find a way to handle this. The less prescription we have in the thing, the better, because prescription tends to overrule the market and prevent the market mechanisms from working.
Okay, so first of all, I wasn't really making a judgment on the standard itself as far as that there hasn't been a case that's necessarily a bad thing. I didn't mean that. What I meant, and I don't think I still have heard an answer, is what would a railroad have to do to, as far as anti-competitive conduct, to permit a shipper under our standard, the present standard, to gain access under the present standards, and maybe that's more in Mr. Sipes' roundhouse.
Well, the board did speak to that in mid-tech, and the ICC, the board's predecessor, spoke to that in mid-tech, but perhaps in language that some of us might find more abstract than we would like. The board said competitive abuse encompasses, quote, classical categories of competitive abuse, foreclosure, refusal to deal, price squeeze, or any other recognizable forms of monopolization or predation. Kind of abstract, but let me try and make it concrete with reference to Dr. Willig's framework. And first of all, I agree that I think it's probably a good thing for everybody that there's not a lot of competitive abuse floating around out there. And railroads have good incentives to avoid actions that are going to cause them to run afoul of regulatory standards, even if the standards are not frequently invoked. People are aware that the standards are there. So, you know, what might rise to the level of actionable foreclosure or refusal to deal? You know, suppose there is an arrangement, a potential arrangement out there in the marketplace, like a through route, where there is currently a single bottleneck carrier who is handling it from origin to destination. A second carrier could come in for part of the route and provide a more efficient transportation arrangement at a lower cost with a net savings to the shipper and actually increased contribution to the incumbent. If carrier number 2 presented that arrangement to carrier number 1 and showed that there was a demonstrably more efficient arrangement that represented a win-win to the two carriers, and carrier number 1 says, I'm not going to deal with you, that conceivably could constitute an actionable claim under the board's competitive access rules. I don't think it happens very often because, as Mr. Burkhart and others have suggested, the railroads have strong incentives to collaborate in those situations, and not collaborate in a bad, collusive way, but collaborate the way that vertically integrated parties collaborate to make a final product.
Yeah, and actually, Mid-Tech is an interesting one to me because in my career I had the opportunity to serve that plant twice. Once when I was on the Chicago and Northwestern, and then years later when I was heading up Wisconsin Central. And the whole rail network in Wisconsin had changed in the intervening years. And this was a paper mill. It didn't have unit train business. It did a pretty good business. A high percentage of their total traffic was exempt under the board's boxcar type traffic exemptions. There was no particular reason for this industry to receive some kind of special consideration that was very much in line with what some rail customers would request today. They didn't get it then, and there was good logic for them not to. Now, if you're running unit trains and you can make the case of on certain types of traffic of market dominance, the board has regulations that address those particular subjects, and certainly shippers have used them, actually with more success in recent years than I think they've had. So I see that as going on. But Midtech was a classic case of onesies and twosies. This industry, everything in there and out was a single car of traffic going to or from some location, and the serving railway certainly needed the revenue in order to continue to provide the service that was necessary there.
Second question, just kind of flowing out of that. Basically what I'm hearing in your comments is the system, the regulatory system in place is more or less working, and it's demonstrated by the success of the system and over the past 30 years. So that kind of drags me back to our last proceeding with respect to exemptions, because it seems as if what you're saying is if there is some kind of unreasonable rate or unreasonable practice, we should allow the present regulatory system that's in place resolve that issue. And I guess my concern in the last proceeding with respect to exemptions was there were certain groups that didn't have that avenue available to them. Obviously, there is the ability to seek a revocation, but I saw in that proceeding there were some groups of traffic that had quite large RBC ratios that were significantly above 180. And would that change your ideas, what you said in this proceeding versus what you said before, that none of those exemptions should be revoked as far as universally speaking for a group of traffic?
As a witness in 704, let me try to set the record straight as to what I thought I meant to say, which is to say that whole-scale revocation of exemptions we did not believe was appropriate, but where there is evidence on an OD pair of a specific shipment of a specific commodity, then that shipper should come in and seek a revocation, and if the facts warrant it, then it should happen. But it should be done on a case-by-case basis, not on a commodity-wide basis.
And this was primarily related to business that was seen as truck competitive. And it is, and the trucks are still very competitive, and very much limiting what railways may have in the context of a local rail market, a monopoly. But I don't like that word at all, because they're operating in a large transport market where they don't have a monopoly, and trucks are hauling everything. And if there's another railway within 100 miles, there's transloads and things of that available. So the exemptions were put in place, I think, on a very intelligent basis. And I don't see anything there that's changed.
One final question. I noticed in the, I guess it's the concerned captive coal shipper state comments that they put in for access, I believe for through routes, a trigger at RSAM for access. And I noticed in your comments that you went down to 180, and I think I've heard some comments in your statements about that being, I think, about $5.2 billion effect on the railroad industry. What, if you know, and you may have already done this analysis in the past due to some of your discussions you've had about RSAM and access and things of that nature, but what do you think the effect of a policy like the concerned captive coal shippers would do to the rail industry as far as monetarily speaking?
Well, I don't know the answer to that question, Chairman Elliott, because to my knowledge, we haven't done the analysis. We could do that, but I do want to make an observation about the Concerned Captive Coal Shippers proposal and link it back to something I said earlier, which is it is a measure of rate relief. It is not a standard. And so to think about their trigger, as I think you call it, as something that would enable them to claim access is, I think, inappropriate, because it is not a conduct-based standard. I don't think you would want to adopt anything like that. But in terms of the RSAM impact, I don't know what it is. We could do that for you.
Just as far as calculating the impact of changes, the numbers, the 5.2 and the 2.6 I mentioned, came from a study that the STB puts out that shows the long-term variable cost and then the revenue by commodity category. So you can basically take whatever ratio you wish against your long-term variable cost of that category. And I don't know what the recent RSAM is. I know what some of them are by railroads. You can calculate what those impacts are, if that's what you're interested in asking. It's pretty straightforward.
I'll do that right now. I'll get on that. Any further comments? Questions?
Mr. Chair, might I make just a closing comment?
No. Yes, go ahead.
Thank you. I'd like to say something that I'm sure you perhaps did not think I would say, and that is I agree very strongly with something Chairman Rockefeller said this morning. He indicated that there's a symbiotic, his word, symbiotic relationship between railroads and their customers, and that is incredibly accurate. There is a symbiotic relationship. We, as he put it, we're out of business without their business. And so when people say, gee, we are locating over in Doha because of rail rates, when people say we're not able to run a second shift because of rail rates, it makes no sense that the railroads would allow that to happen. And every day I submit to you, and I know you have given eloquent talks about reaching for middle ground and trying to work together. It might be difficult inside the Beltway, but I submit to you that out there in the real world, each one of these railroads is sitting down with their 25,000 customers and talking every day about how to work better, how to make them more competitive domestically and on world markets, because if they're out of business, we're out of business. And therefore, that's what we do, is work with our customers to get them more business. So I just hope you keep that in mind, and as the railroads come up, I'm sure they will be able to give you much more specific detail about how that works. But thank you for and I apologize to the Vice Chairman for an overly broad statement. Of course, this is a very excellent proceeding. I just was indicating that maybe we don't need to go too much further. But thank you.
We appreciate you coming today. Thank you very much. No, the CEOs are 2 panels down. Okay. I'll just wait for Okay, we're going to begin now with panel number 4, and I believe that's just one group, the North Carolina Department of Transportation, and you have 5 minutes. I don't think your mic's on.
Mr. Commissioner, here we go. Thank you.
Thank you.
Thank you for the opportunity to speak today and provide testimony on behalf of the state of North Carolina. I'm Jim Trogdon, Chief Operating Officer for the North Carolina Department of Transportation. Transportation Secretary Gene Conte would have been here and wanted to be here, but unfortunately sends his greetings and regrets that he's abroad and could not reschedule his previous commitments. But he and I certainly commend the board for your timely inquiry into this important matter, so that the key economic well-being of shippers, rail carriers, and of course the public interest can be discussed and reviewed. Much of the testimony I'm sure you've heard on the record so far in this matter reflects the competing commercial interests of shippers and rail carriers and railroads. We felt like it would be important to provide the perspective of the public in the state of North Carolina. Our citizens certainly believe that this proceeding is important, that shipment of our commodities through rail and all transportation means are important, and certainly in this economy how we can be more effective is a very important topic to our state, all of our economic development opportunities, and our citizens. North Carolina has invested heavily in improving rail infrastructure in our state to benefit both passenger and freight service. The Department of Transportation and our state-owned North Carolina Railroad have invested more than $400 million over the last decade in modernizing rail infrastructure, improving safety, and enhancing the capacity for carriers, shippers, and passengers. In addition, more than $625 million in funds have been spent for safety, capacity, and reliability from both federal, state, and North Carolina Railroad assets. The North Carolina Governor, Beverly Perdue, established 2 years ago the Governor's Logistics Task Force, specifically requiring us to look at, over those last 2 years, ways to enhance our transportation efficiencies to include ports, rail, aviation, and highways and trucking. And that was to make sure that we as a state can better compete in the local and global economy and provide much better access to jobs for our citizens of our state. And we are actively looking at any way we can to improve the synergies between our ports, both freight, rail, aviation, highways, and all of our logistics, and provide services to meet the needs of our economic demands for our state. And our citizens have clearly a direct stake in this proceeding, so that can possibly result in improving freight rail competition for our state. But the current state of rail competition in North Carolina significantly restricts our state's ability to compete in the global marketplace and to adequately serve the needs of our shippers seeking to transport goods to, from, and through North Carolina. We have 2 commercial ports in our state, one at the Port of Wilmington and the other at Morehead City, and both are effectively captured by the positions of the Class 1 railroads that control access to these for rail freight only. In the case of the Port of Wilmington, there is currently one Class 1 railroad that can provide intermodal service from Wilmington to Charlotte and beyond. Despite bridges and other constrictions that were raised to allow double track operations along this corridor, that service has not been established because the rail carrier quotes that were provided from Wilmington to Charlotte were approximately twice the rate of truck movements for the same destination, and approximately twice that for other destinations between Charlotte and other ports, specifically Savannah. We are also interested, because Charlotte is our largest retail market, in how we can make that Charlotte facility much more competitive with the Port of Wilmington, because that would provide us access from our ports to destinations beyond Charlotte, to include Greenville, Spartanburg, Atlanta, and Memphis. Without competitive rates, the Port of Wilmington is not able to attract ocean carriers that can reach beyond one-day truck trip limitations. and most ocean carriers are seeking to access markets other than just those in our local area and well into the Mid-Atlantic region. And this requires intermodal rail service because trucking cost that distance is specifically prohibitive. This lack of trade lanes and ocean carrier service severely limits the ability of North Carolina businesses and our ports to reach these global markets. This translates into jobs lost for our state and higher costs for transportations of goods and services. The situation in Morehead City is similar. As illustrated in a recent example, last year Spirit Aerosystems, located at a major manufacturer in aircraft components, located at a facility in an economically depressed inland county in eastern North Carolina, to build aircraft components for transshipment to Europe for assembly for Airbus aircraft. The original plan was to move this cargo by rail from the Kinston area to the port of Morehead. North Carolina constructed a 6-mile rail line to make the connection to the Class I carrier at significant expense to us, but the Class I rail carrier's rate that was quoted was not competitive, even with a much higher than average truck rate. The quoted rate was approximately 10 times that of trucking. And again, the private carrier's position prevents the safest, most efficient movement of goods by this important new corporate citizen to our state. Spirit Aerosystem ultimately will hire approximately 1,000 employees. 80% of the wages are at an 80% higher average wage rate than most of the counties in eastern North Carolina experience. We definitely need a very competitive rail service to serve this shipper and allow us to attract other shippers and manufacturers to this region. And a final example I will provide is the intermodal freight service in the Charlotte area. North Carolina has partnered with 2 Class I carriers, both Norfolk Southern and CSX, to invest in separate intermodal facilities in the Charlotte market. An alternative would have been one joint public-private investment to create a union of intermodal facilities in that region, a single facility that could scale to handle the needs of both carriers, and optimally sited to balance the needs of the carriers and the entire transportation network. The public made repeated requests to both of these Class I carriers to consider a single facility, but neither would meet to discuss such a concept or project. The result was the 2 facilities being constructed at a much higher public and private cost. North Carolina and her citizens clearly have been negatively impacted by lack of competition among the freight carriers in our state. Our state policy is certainly to invest in all modes of transportation, and we will continue to do so, but moving forward, we would want to do it in the most effective and efficient way possible. And our hope is that these examples are persuasive in considering that we must get some relief from these tight controls on these individual rail lines, and that whatever the terminology, the Secretary likes to ask for improved access. So we would like improved access for other railroads and other appropriate regulatory changes that can increase our competitiveness in the rail freight industry. And we offer to work with you certainly as a Department of Transportation and to support your efforts in advancing the discussion in any meaningful way to achieve change and improve freight rail service for all of our customers and our citizens. So I thank you for the opportunity to participate, and will answer any questions that I may.
Thank you for your comments. Commissioner?
Does North Carolina have a proposal for changes to how the changes to the board's policies can address some of the issues that you face, some more specifics?
Mr. Commissioner, I don't think we've had any specific proposals other than the Secretary did provide some written ideas or objectives, because this is a series of what we would consider probably many proceedings and meetings. He did have a couple of strategies on improving some competitive pricing and improved access, but I think probably the one that he discussed with me the most was how to make the entire pricing process a much more public, transparent, and open process where you could see quotes that are being made on various facilities across the nation. A great example is our port, the rate that was quoted from the port of Wilmington to Charlotte, 2 times the truck rate, and the port has been asking for quotes from Charlotte and beyond to other locations, and still have not gotten quotes to those other locations beyond the Charlotte intermodal facility.
I know Secretary Conte fairly well. I worked with him many years ago on high-speed rail issues and higher-speed rail issues, I should say, in North Carolina. I know that's a great interest of his. And as a matter of fact, my experience with North Carolina and the North Carolina DOT and rail has been that it's been heavily focused on passenger issues. So I am glad to hear that there's a greater emphasis being put also on freight issues as well, as they're critical to the North Carolina economy. You mentioned a couple of projects that you had done, and I was interested in 2 things. One, of the several $100 million you mentioned, how much of that was basically freight related? And then secondly, you mentioned building a 6-mile line that the North Carolina state paid for, and then got a rate quote from the railroads that was 10 times the truck rate.
Yes.
Wasn't there an agreement before you built the line as to a commitment for carrying the traffic at a known rate, or did you build it and expect that they would come and be reasonable?
The answer to the first question is we do spend a lot of our both state and federal grant money on improving rail crossings, rail safety, sealed corridors, removing crossings. Mm-hmm. We are focusing today and in the future on mutual benefits of passenger and freight rail, particularly on the line from Raleigh to Charlotte, and then Raleigh both going north into Richmond and beyond. The second part of your question is, and I'll defer just for a moment because I wasn't at the department when the rail was negotiated, but my assumption was we had some initial agreement, and then when the shipper finally got the quotes, because as you know, initial agreements are, you never know the dimensions, commodities, what they all look like, but that the final quote was much higher than the initial concept. And I'll defer to Pat Simmons, who's our rail division, on the specifics.
Thank you for the question, Commissioner. Yes, we had a working agreement with the recruitment team, which included the Freight Railroad, to recruit Spirit Aviation to come to North Carolina, create the jobs. Part of that discussion that secured that 1,000 jobs in eastern North Carolina was the commitment to provide service. We agreed to build the rail line, and the railroad agreed, of course, to provide the service. But as Jim pointed out, when it came to pricing, then we were priced out of that competitive marketplace.
Thank you. That's.
Actually, I don't really have a question, but more of a comment. When Mr. Hamburger left, he kind of ended on a high note, talking about the effort that the individual railroads take to reach out to their shippers and resolve issues, and the fact that, you know, if the shipper isn't there, the industry goes away. And hopefully whatever carrier or carriers are serving North Carolina, I don't want to call anyone out, but hopefully they'll reach out and have a conversation with the state of North Carolina, because I think maybe something productive could come from that.
Well, and one recent change for us is that our ports authority was an independent authority, and you know, based on our latest legislation from our state legislature, our ports will now come under the Department of Transportation, and part of the direction from the Governor's Logistics Task Force is to build a tighter, if not administrative, a tighter policy planning, coordinating relationship with all of the aspects of our industry. And so we're moving very hard to do that, to make sure that the strategies that we're working on the highway and bridge side matches the strategies that we're working with the ports, and then work with the railroads and aviation and all of our other industry clusters to make sure that we're doing that. So I believe that we will work very hard in improving communications among the Class 1 railroads and making sure that the ports are speaking louder than just by themselves. but we certainly look for every opportunity to work with this board in improving that communications.
And I don't have a question, but I do want to mention, kind of flowing out of the Vice Chairman's comment, that we do have a program here at the board called I always like to give a free plug, the Rail Customer and Public Assistance Program, which has been quite helpful with shippers, ports, communities, etc., and resolving issues. Not that we won't take full consideration of your comments in the context of this proceeding, but it is a very useful avenue to begin communications where they may have stalled by having the board help reach out. So I just wanted to recommend that to you as well. Thank you very much for your time today, and we greatly appreciate you taking that time.
Thank you.
Thank you.
I'll now call forward panel number 5. Just as a matter for people's schedules, I think what we're going to do is push forward and try to get in the next 2 panels and then take a lunch break for about an hour, because I understand in some of these lengthy proceedings people like to get out and about for a little while, so we're going to try and do that today. But I'd like to at least work forward till around 1 o'clock and then take a lunch break at that point in time. Okay, now we'll start with panel number 5. I believe we'll begin with the Alliance for Rail Competition. Mr. Whiteside, you have 10 minutes.
Chairman Elliott, Vice Chairman Begeman, good to see you, and Commissioner Mulvey. My name is Terry Whiteside. I'm honored and pleased to be here today on behalf of the Alliance for Rail Competition members and the WEAC commissions across the country. ARC members and the WEAC Commission exist to represent the needs and interests of their members, and I'm the principal of Whiteside & Associates in Billings, Montana. I serve as chairman of the Alliance for Rail Competition and representing the Montana Wheat and Barley Committee on that committee. I also am a transportation consultant to the Wheat and Barley Commissions in Montana, Colorado, Idaho, Kansas, Nebraska, Oklahoma, South Dakota, Texas, and Washington, which kind of covers the mid-central part of the country up in the northwest. ARC is an association of shippers that are captive to railroads for significant portions of their freight shipments. And ARC members include shippers of agriculture commodities, coal, chemicals, glass, manufacturing, rail customers, and other bulk commodities consisting of large companies, small businesses, shipper associations, and groups. So ARC and the WEAC commissions are subscribers to and supporters of the joint written comments and reply comments by the interested parties. ARC is appearing today to highlight aspects of this matter particularly concerned to its members. The main purpose of these comments is to urge the board not to lose sight of the shipper's need for protection against unreasonable rates and unreasonable railroad practices as it directs its attention to competition issues. In many regions of the country, rail-to-rail competition is non-existent for most shippers, and it's unlikely to, it is likely to remain non-existent no matter how much effort the board puts into eliminating or reducing anti-competitive policies and precedents with programs outlined in this proceeding. That does suggest that every effort needs to be made by this board to increase rail-to-rail competition. In fact, the situation cries out for increased and proactive efforts by the board to make increasing competition one of its prime directives. I was an old Star Trek fan. So. In the vast hinterlands, where distances are great, attracting effective competitors for monopoly incumbent railroads is an unlikely scenario at best. Many of the ARC members ship less than truckload shipments from thousands of origin-destination pairs. Many other ARC members are large volume rail customers that ship between a few or single origin destinations. What's common between them? They're all captive, they'll have little rail-to-rail competition. The USDA study, USDA and DOT study recently in April of 2010 indicated that a number of crop reporting districts in many of the western states have gone from 4.25 down to 2.58 competing railroads, and with equivalent RVCs in the 180 to 240 range, 10 in the period of 1985-92, and then 24 in the period of 2003 and 7. Some of the RVCs that we've calculated in those grain rate areas include Montana, very high ones in Montana, North Dakota, South Dakota, Nebraska, Kansas, Colorado, Colorado, Oklahoma. The level of rail competition in the United States presented in this proceeding is of enormous importance. Action has been delayed far too long by the STB and the ICC before it, and the vast majority of the nation's captive shippers have been waiting really since 1980 for a methodology that will implement for their freight the command of Congress that rail rates on captive traffic must be reasonable in 49 U.S.C. 10701 D1. As stated in our comments, under current conditions, railroads can easily make rate cases an ineffective remedy through the tactics of monopoly pricing. They can say to the captive shippers, and they've done this, that if the shipper doesn't like the 35% increase that it's proposing, they'll publish a 50% rate increase, effectively making the shipper an offer it can't refuse. I have a situation where a major company wanted to do manufacturing and ship all of its product out of country. Sat down with the railroads. They quoted us contract rates higher than their tariff rates. When we pointed that out to them, they went home and canceled the tariff rates and says, now you have to deal with us. Now, we got the contract done, took a year and a half, but those are the kinds of things that we're faced with in the field every day. What captive shippers desperately need is a recourse to effective regulatory remedies that force market-dominant railroads to moderate the rate gouging by ensuring that the rates on captive shippers are reasonable. Board members, what's needed here is the guiding hands of this board to provide surrogates for rail competition for those shippers that do not have rail competition afforded them. Plainly, the railroad's goal is to prevent the board from considering, let alone proposing for public comment, any changes in the current rules and policies affecting rail competition. Railroads argue that there are no new circumstances warranting reconsideration, contending that their improved financial health with revenue adequacy achieved or imminent for the Class 1s is unrelated to the effectiveness of rail competition. We heard it this morning. They argue further that re-regulation is, in any event, the way the board should address the industry's improved financial condition. ARC and our groups certainly agree with that the STB jurisdiction over unreasonable rates is important. We discussed that in our opening comments and our reply comments, but the railroads claim that the railroad rate remedies are adequate and obviate the need for increased rail competition is just untenable. Rate remedies are far from perfect, even for the coal shippers. The captive shippers, which have received virtually all of the rate relief from the ICC and the STB since 1980. The ICC and the STB remedies for non-coal shippers have been non-existent for much of that period. And because they're not being utilized does not mean it's a perfect system. In fact, the board should not assume that the railroads will never drive shippers out of business. ARC members who operate or used to operate 26 and 52-car grain facilities have seen their enterprises disappear because 100-car elevators are more efficient for the railroads. Similarly, if the same amount of electricity can be generated from fewer power plants, or the same number of cars can be built with fewer factories, or the same number of chemicals can come from fewer factories, it's not safe to assume that the railroads will not use their pricing power to encourage or force the shutdown of facilities that they see as less efficient from a transportation perspective. We've seen markets, whole markets, in the West, major markets for export of grain, where the railroads have cut off access by eliminating unit train rates. So as long as the same volume moves by rail, they're fine with it. Let me see if I can capture the railroad's arguments in 3 sentences. The railroads argue that government intervention is necessary to ensure they earn adequate revenues. At the same time, railroads argue that no government intervention is necessary to limit their monopoly power. And if anything is changed by this board or Congress, the future railroad system will collapse because of insufficient reinvestment won't occur, and the sky will fall. So even though rail competition was called for in Congress in 1980, let's go back to 1980 for just a second. Railroad bankruptcies were here. The railroad said you can't do anything about the captive shipper problem because the railroads are too weak. We need to get stronger. 1996-99, last of the major railroad mergers. Railroads are saying, well, they will be more robust, efficient, and competitive in the future, but the railroads say they can't do anything about it, about the shipper issues, because they need to complete the consolidations and get financially stronger. 2011, railroads are the 5th most lucrative industry in the United States. Railroads can't say you can't do anything about it now because of the requirements for future reinvestment. If not now, when? Thank you, Mr. Chairman.
Thank you, Mr. Whiteside. Next we'll hear from the National Association of Wheat Growers, Mr. Hurst.
Sure. Chairman Elliott, Mr. Mulvey, and Ms. Bigman, members of this board, my name is Wayne Hurst. I'm a wheat, sugar beet, dry bean, and barley grower from the Burley, Idaho area. I currently serve as president of the National Association of Wheat Growers and have served in the past as an officer of the Idaho Grain Producers Association. I also serve with the Alliance for Rail Competition, and I represent wheat farmers with the BNSF Ag Rail Business Council. I am honored and pleased to be here today on behalf of the National Association of Wheat Growers and farmers across the country. The National Association of Wheat Growers is a federation of 21 state wheat grower organizations that work to represent the needs and interests of wheat producers before Congress and federal agencies. We are grower-governed and grower-funded, and we work in areas as diverse as federal farm policy, trade, environmental regulation, research, and, like today, transportation. Members of the board, railroads are vital to agricultural production and to the value chain. They are extremely important to us. And in my experience, the people who run them are good, smart, hardworking Americans, much like American farmers. In fact, many of those I have worked with over the years have farm backgrounds. But those facts do not take away from the reality that there are billions of dollars to be made each year in the railroad business, and the pressure to maximize that profit is very real. Agricultural producers are price takers rather than price makers, with little control over the price they receive for their products. They are unable to pass cost increases on to customers and must absorb those costs because of a lack of market power. In most cases, our grain is priced on the 3 electronically traded wheat futures markets here in the U.S. However, this is not the price that we as farmers receive, because marketing and transportation costs, what we call basis, are then applied. In most cases, this basis is subtracted from the wider set futures price to give the available cash price on the local grain collection point. Increases in transportation costs result in larger basis and therefore lower cash prices that come back to the farmer. For agricultural shippers with no cost-effective alternative to rail and located far from end-use markets, rail is the only transportation available. Wheat and grain growers know that an effective railroad system is necessary for the success of the wheat industry. However, they continue to face many problems with rail rates and service. Study after study has shown that with each successive rail merger over the last 30 years, there has been a substantial reduction in rail-to-rail competition. Over time, rail customers in the United States have grown more captive to single rail carriers. As captivity levels rise, a larger and larger share of the cost of transportation has been shifted to rail customers and to state and local governments. Helping our members find solutions to these freight problems remains one of the National Association of Wheat Growers' top priorities. I will talk today about rates and service, and specifically how rail captivity interacts with these. I will also describe the effect we believe a proactive and empowered STB can have on finding solutions to these problems. Since the passage of the Staggers Rail Act of 1980, the degree of captivity in many wheat-growing regions has increased dramatically, and America's farmers continue to experience both service issues and ever higher freight rates. We have had continuing rail equipment spot shortages since the railroads started aggressively consolidating and merging in the early 1990s. We continue to have grain piled on the ground in many states in the late summer and fall due to lack of rail equipment availability. 20 years ago, there were multiple transcontinental railroads servicing agricultural regions. Today, however, whole states, whole regions, and now whole industries have become completely captive to single railroads as a result of many railroad mergers that were allowed by this agency. At the time, those merging railroads promised greater efficiency and more competition. In the wheat industry alone, there are substantial pockets of captivity in at least 14 states stretching from Texas to the Pacific Northwest that are primarily attributable to the effects of mergers. In these areas, the rates are higher and the service levels are not the same as service that is provided in areas where there is rail-to-rail competition. In October 2007, the Government Accountability Office issued a report, GAO 07-94, entitled, Freight Railroads, Industry Health Has Improved, but concerns about competition and capacity ought to be addressed. Confirming what we in the captive shipper industry have been stating for years, those areas that are captive pay the highest freight rates, yet receive some of the worst service. The Christensen study confirmed that the high freight rates in captive areas. An extensive USDA study further revealed that the GAO correctly established the link between single railroad access and elevated percentage of tonnage above the threshold for rate relief. In our own studies within the grain industry, examining the RVC levels on rates to common destinations of the Pacific Northwest, we find large areas moving at rates considerably above the threshold. Confirming the findings in the GAO study, the Christensen study, and the USDA study. For most of us, rates remain high. Farmers experience and suspect it, and both government studies and work by independent consultants confirm it. Lower prices and incomes hinder farmers from borrowing funds to purchase fertilizer, seed, and machinery, thus reducing economic prosperity in rural areas. Higher transportation costs also affect the competitive position of U.S. agricultural products in highly competitive export markets. The rates agricultural shippers pay for rail transportation can facilitate or inhibit American competitiveness in world agricultural markets. This point is of particular concern for wheat producers, since about half of our crop is exported each year. I have come to realize in my meetings and exposure to the railroads that they are under internal and external pressure to maximize profits, because as monopolies they can. I've heard division managers speak of expectations within their companies to deliver profits. It's also obvious that their stockholders and lenders expect large returns and have been receiving them. Warren Buffett didn't buy the BNSF because he thought it would be fun to own a railroad. He is very much aware of the power the railroad has in controlling its ability to produce revenue. When I testified a few years ago before the House Transportation Committee, a few days before the hearing I was out hauling hay, and I got a call from a guy from the Bank of New York asking me why I was against the ability of the railroads to attract capital. The investment and banking industries play a huge role in this issue, and the excess rates that we farm families pay go directly to those investors, to the pension funds, and bankers involved. There needs to be a mechanism to protect the captive shipper in this equation, much like a governor on a tractor. I believe that within the current system, that mechanism should primarily be a proactive STB. Farmers are willing and expect to pay their fair share of costs to get our goods to the market, but we in most cases pay far more than we should. As a farmer, I liken it to shopping for a new pickup. Say a truck on the lot is marked at $30,000. At that price, the variable costs are paid, you might call it 100% of RVC. The factory fixed costs are paid, another 30 to 40% of the RVC. and the investors receive a return on their investment, roughly 40% of RVC. So if the pickup at $30,000 pays all the labor and other bills, including the return on the investment, if I have to pay $50,000 because I have no other choice, that's 300 RVC, you might say. Something needs to be addressed. Something's not quite right. On a brighter note, it has been my understanding and experience in recent years that, generally speaking, service has improved. The economy has slowed, and railroads have had the capacity to meet service needs. Railroads have gradually realized that in many past complaints were service-related, and they affected the handler's profitability. So they may have made moves to mitigate these problems while transferring the extra cost directly to the customer, the farmers. In other words, improved service with faster delivery times helped the handlers and the farmers, but we, not anyone else, have paid the bills for it. I am very concerned about what will happen to service when the economy becomes more robust and competition for priority service increases. We agricultural producers truly believe that a healthy and competitive rail industry is essential for our continued viability on a rapidly developing world market. However, with continuing service issues and increasing rail rates coupled with a regulatory agency that does not meet the needs of shippers, it is increasingly difficult for agricultural producers to remain competitive. The proposals outlined by this board, such as terminal access and bottleneck, might mark progress in dealing with these specific issues, but they will not solve captivity problems. The distances for us are too great for these remedies and generally work. Farmers believe that both railroads and shippers would be better off with more competition. We fervently believe that a strong, proactive STB can provide a host of benefits where competition cannot physically be created. We believe that the STB needs to be the facilitator and the catalyst for increasing competition in this historically strong industry of grain handling. We believe the railroad industry can survive and prosper in a competitive environment, and indeed we know from history that competition breeds innovation and efficiency. Finally, as a farmer, as a taxpayer, and as a shipper, I encourage you to take a proactive role in addressing shipper concerns. I appreciate, again, the opportunity to speak before you today, and I look forward to continued discussion about these issues.
Thank you, Mr. Hurst. We will next hear from Mr. Keith from the National Grain and Feed Association. You have 10 minutes.
Yes. Thank you very much, Chairman Elliott, Vice Chair Begeman, and Commissioner Mulvey. On behalf of NGFA, we appreciate the opportunity to testify at this, what we consider to be a very important proceeding. We thank the STB for initiating this dialogue on rail competition. Our association has about 1,000 member companies that own and operate some 7,000 facilities nationwide, both shipping and receiving. We have exporters, we have flour milling, soy processing, feed mills, corn mills, dry ethanol plants, and feed operations. We think agricultural shippers are very much in a unique situation in the transportation markets, as there's not a lot of heavy volume shipments from point to point. There's a great diversity in shipping points and receiving points throughout the marketplace. This is one of the reasons we're quite interested in trying to resolve the reciprocal switch situations where they are problematic and creating barriers to entry into markets. Competition is very important in the rail markets and the national economy, we believe. The U.S. rail industry was in drastic financial shape in the 1970s. The main reason for this was that regulation by government did not allow innovation and market forces to govern the railroad's actions in the markets. We're in a much different situation, a much improved situation today, and we have considerable market freedoms for the railroads to run their businesses. We think that's a very positive development by and large. Given the positive factors that have contributed to rail markets' success, we would certainly discourage the STB and Congress from adopting any changes that would further reduce competition in that marketplace. Competition is good for industries, we believe. We think it's healthy for those industries and the employees they hire. It maintains a competitive edge that helps companies succeed long term. Encouraging competition, in our mind, is not re-regulating. In the United States, where there are relatively short hauls and trucks can compete, rail rates do tend to be lower. In export movements where there are competitors that have access to barge transportation, you certainly see lower rates than you do otherwise. So there are locations from which agriculture shipments originate where there is adequate competition. In some markets there is adequate rail-to-rail competition too. Agriculture is not just after low rates. We see other things that we need in the marketplace. We certainly need good service, reasonable rates, reasonable business terms, and we also need a cost-effective method to resolve disputes. I'll talk to that in just a moment. From our perspective, we think a major benefit the STB could provide is to review policies relating to switch charges. And we see switch charges in some cases that have increased over $500 per car, or roughly 500% of variable cost. One idea that we have is that you don't set absolute rates on switch charges like the Canadian system, but you set a benchmark maybe of 180% of variable cost, and beyond that becomes the burden of the proof shifts to the carrier to justify it being reasonable. We do believe that carriers do not want to be re-regulated, but we also believe they should not have a completely free hand in cutting off existing physical and economic access through closures of switch points. To allow such autonomy on switch charges, we think would have a strongly negative impact on the competitive fabric of the entire nation's economy. Since 1980, railroads have lost market share in our business. In 1980, they handled 50% of the commercial rail volume. Today, they handle about 35%. It varies a little bit, but that's kind of a long-term average. Our industry does not want this industry, the rail industry, to lose more volume. We don't like the downward trend in that business. We need railroads to carry grain. I mean, major production areas in grain are 1,000 miles from port, and often 1,000 miles from their utilization points if it's domestic business. So we need the railroads. Our view of revenue adequacy is has become a less important term than it was certainly back when the Staggers Act was passed. We think it often creates unnecessary barriers to business dialogue between the shippers and the railroads, and it creates problems on solving market access challenges. Lastly, we think that carriers and shippers alike need better access to problem resolution. I think the commissioners understand that NGFA has a private rail arbitration system that we use between carriers and grain and feed shippers. And it's been very transparent. It's been very useful, we think, to creating a better business dialogue within the industry. It doesn't solve all problems, but I think one thing that it does do, and the STB might want to consider this going into the future, is that it allows for final resolution. There is an appeal process through our system to go to one appeal, but once an arbitration is done, you can't appeal it in court. It's my understanding that the STB may not have the authority to create an arbitration system that would have a final decision-making authority. That the decisions would likely still be appealable through the STB. In any event, we would stand ready to work with the STB on trying to establish a better voluntary system of problem resolution. Again, we appreciate very much the STB conducting this review of rail competition, and we appreciate the opportunity to be involved. Thank you.
Thank you, Mr. Keith. Thank you, panel, for your comments. Just a few questions. First of all, I'd just thank you, Mr. Keith, for your comments about the arbitration that you have available with the NGFA, and we appreciated your comments in the arbitration proceeding. They were very helpful, and we look forward to moving ahead with that proceeding as we analyze the comments in the future. Just kind of the same question I had to the other panel of shippers. I hear a lot of statements about railroads aren't competing, and I've heard some statements with respect to if we open up access and the railroads aren't competing, that's not really going to be helpful. So I pose the same question to you that I posed to the other panel. If you had your choice with that in mind, bearing that in mind, what would you rather have? Would you rather have more access, or would you rather have more aggressive rate proceedings that maybe gave you a better avenue to come to the board, and maybe that's something that's less expensive, that's not so resource, there's so much resources involved. So I'm just kind of curious to hear what the shippers think on that, just based on their comments.
From our perspective, it's ultimately, just I think better rates, frankly. That's the bottom line. Right now, I think most of us are being served fairly well by the railroads, and they're efficient, and they're our partners. But we're paying for it, and there are forces, like I say, at work that are driving high rates and maximizing profits. And we need somebody that we can access fairly quickly and inexpensively and effectively to say that's enough.
Mr. Chairman, it's interesting because on the one hand, we hear from the railroads that you can't change anything, but the real reality is the more avenues, the more methodologies we have gives us the ability to compete and to negotiate. One of the things that we find in I share Ken O'Keefe's ideas on arbitration. A very robust arbitration system would be extremely helpful. In fact, we have many members in ARC that like final offer arbitration like they have in Canada. But the whole point is that when I talk to the lawyers involved in final offer arbitration in Canada, they say they don't use it very much. I said, why? They said, because we can negotiate because we have it. And we can negotiate if we have strong access. We can negotiate if we have strong capabilities of resolving rate issues. The more tools we have, the more resolution we will have in the field with our partners, the railroads. We need the partners. We need the railroads. One of the things that's most interesting, I did a survey one time and I asked our members how important are the railroads, and what they said was they're more important to us than they are probably to themselves, because we have no other alternatives. So the more tools we have, if you will embrace those tools and make them strong, guess what? Then we won't be here.
I'd say on that we believe we need a reasonable small rate case standard process. I don't think that people are going to use it too much in our industry, even if it was very advantageous. So I think the access probably is more important to us. We prefer not to litigate if at all possible. But to set up a system where you have access to litigation and it's reasonable litigation, then it does encourage people to talk, and it does work. So Terry's right about that.
Okay, thank you. I know you mentioned that there are some areas, and I'm aware of some areas where you only have one railroad that's really available in the state. And I know, I guess Montana comes to mind, and I know there's been some things done between the ag groups and the railroad involved. And but what do you have in mind? I mean, it seems like there really isn't an availability as far as any type of access up there, because there really is only one railroad. Do you have any ideas in mind as a way to solve that issue?
Mr. Chairman, I think I would go back to what we just talked about. Working with our partners, the railroads, is important, and there's been some progress. Is it a total solution? I liken it to growing a garden. You need lots of tools. You need hoes and rakes and shovels and whatever. And it's one of the tools that's working for us. But I think the most important thing is having a strong STB presence saying, look, here's a reasonable small rate case procedures that you can use. Having arbitration, a strong arbitration provision. Having I don't think terminal access, for example, is going to work in Montana. There aren't any. It's too far. North Dakota, it's not going to work. It's not going to work in South Dakota. It probably won't work in major portions of Colorado. So, but having those tools gives us the ability to sit down and develop a comprehensive policy with the railroads. The railroads are not totally unreasonable. The railroads are doing exactly what they're allowed to do. And, you know, I've sat down with farm producers and I said, look, if you could go and sell to an elevator down there and get a better price than everybody else, would you go do it? And they said, yeah. And I said, would you feel guilty about it even for a second? And they said, no. So they're doing what they're allowed to do. What we need is some help with some various different tools to be able to build the garden. I hope that helps.
Mr. Chairman, if I may, I've been associated not directly in the Montana workings, but I've been exposed to them quite a bit. In fact, there's some talk about trying to do that on a national level. But my experience is that it has been, I think, helpful in some people's views, but there have been, in the few cases that have been worked on, there have been some winners and losers. And there's great political and economic risk involved, and it's limited to a small group geographically. And currently, only wheat growers are involved. There are other shippers as well. So we need, I'd say, some widespread board or something to be accessible to all players and all folks involved.
Just one final question. You've mentioned, having access to a simplified rate kind of case system, and I know various groups have advocated for raising the limits on the simplified SAC and the 3 benchmark. Do you guys have any ideas on that as far as how high you would like to see the limits go, or are the limits okay, or is it the process that's not working?
We need them higher. And I'm going to get in trouble no matter what I say to you, so at least double where they are now. We have to get them into the range where, see, remember, under all of them, we're going to end up with 240, 250, 270 kind of numbers so for RVC. So we need them high enough that and long enough that we can take an origin destination pair and it makes sense to litigate it. Will we litigate it? Let's hope not. Let's hope that the possibility of litigating it gets us to rate resolution or service resolution wherever we are. But we've got to have them at least doubled, and then I'm sure that some of my friends behind me will say, no, you got to have them a lot higher than that, but I think at least doubled.
We've got a policy position of raising it to $3 million. We think that the problem with grain markets is if you litigate at a particular point-to-point movement, you don't know how long that movement is going to be economic just by the market pricing. So you really, it's trying to evaluate what the case is really worth is quite difficult for agriculture shippers.
Thank you. I don't have any further questions, Vice Chairman.
No, I thought your questions were really informative, and your answers were very helpful. I think it's great that NGFA has been so successful with its arbitration process, and the reason you've been successful is that the industry has agreed to participate. And so I'll really be interested when industry representatives come back before us as to, is there a way that we could get you to participate in arbitration process here? And we have one at the board, but it's never been used. I know the chairman has been working to try to kind of get it reinvigorated or invigorated for the first time, but whatever we could do to try to resolve cases, or actually avoid the cases, but actually resolve the conflicts prior to it becoming a case, we should all try to be working toward. Really, I think the only question that I have, because I've kind of heard from all of you guys over the years, and it's been, very informative to some of my thoughts on all of this. But when the STB was established, since it was established, it finished the simplified SAC process, established the 3 benchmark process. Really, the mediation process has, I think, really taken off in the last few years, and there's been, some solutions to kind of reduce caseload, et cetera. Are those avenues sufficient? Is it just that we need to maybe consider increasing, the thresholds, or is there another proposal out there that we haven't thought of? I mean, do we need something even more, super simplified 3 benchmark? I mean, have any of your customers or any of you utilized the processes?
It's still pretty complex. I mean, it's not low cost to bring a case. I mean, it's nothing like a SAC case, but it's several $100,000 to bring a case is not uncommon. And so there's still quite a barrier there. But the fact is once you create a process, it just sets the stage for people to talk business, and to try to work things out better. And so we think it's an important step. We think it's not quite as rich as it should be to make the process really work. In terms of mediation versus, I think the mediation process at the STB is helpful today. I don't know that we've had many members use that process, but on the arbitration side, if the arbitration only becomes one more layer in problem resolution and everything gets appealed to the STB anyway, then I'm not sure it's that helpful. And maybe that's the big discouraging factor for STB arbitration today.
I think on arbitration, too, we have to guard against a process that the railroads have used before, and it's what I call gaming the system. They come in with arbitration at 400% or variable, and we come in at 180, 200, and they're hopeful that they can get a 300% decision out of that arbitrator. So they come in very high just to be able to get it down to where they wanted it anyway. And so I think that's the problem. That's why final offer makes a lot of sense when they use it in Canada, because they both come in with their final offers and the arbitrator has to pick one or the other. Where in our arbitration process, the arbitrator picks somewhere in between, and it leads itself to a gaming process. That's of concern, but I think those kind of things can be worked on by this board, and we can set up a procedure where it becomes a tool. But I share with what Keith's saying. The system, if what we're doing is starting to layer different things that can be done, it just becomes a time-consuming process and doesn't really resolve anything.
Commissioner?
Yeah, thank you. I just last week was out visiting agricultural interests in Indiana. I was hosted by the Soybean Council and got to see a number of soy processing facilities, and it was very interesting. But what I was told out there is somewhat different from what I've heard here today. For example, I didn't hear very many complaints about rates. Rates are particularly high right now. I think a lot of satisfaction with overall prices for agricultural commodities, and so the rates weren't the issue. The issue I kept hearing about was service, and that too often the railroads call the shipper up and say, "Oh, we need to have your cars loaded by tomorrow." So they call in all of these people. They all work time and a half and overtime. The shipper pays for all of those extra costs, and then the railroad doesn't show up. Or the locomotives aren't available, or crews aren't available, and this seems to happen time and time again. And I was wondering if that was any of your experience, that the problem today is more service than it is rates, at least today. Terry?
Commissioner, no, I think it's rates more than service issues. The situation you describe, I've heard complaints from many elevator operators where the cars are delivered on Friday night and they have to have them out by Sunday morning, and so they've got to call the crews in on the weekends, and then the railroad doesn't pick them up for another week. That happens, but those are complex problems. I think if you get the rate problem solved, then we'll start worrying about the service problems. But sometimes the rates have to be solved before the service problems become an issue, and it's not the other way around. So I think in general in the West we're seeing issues. The conversations I have with most of the wheat commissions and most of the farm producers are about rates and basis points right now.
And And I would concur. However, service has been a big issue. I mean, for years, if you wanted to hear four-letter words, all you had to do was call up an elevator and ask them how the railroads were treating them. You got an earful in a hurry. And that was common. And now, for example, just this last winter, I called up an elevator operator and said, how are the railroads? And he said, he said, service is not bad. You're just paying for it. And that's what I'm hearing. And also my exposure, frankly, with the BNSF and from what I understand, the UP, they have been working hard internally to improve service. And I believe that they have. At least that's what I've seen on their internal workings. That's what I've been impressed with, and that's what I hear on the ground. However, like I say, I mean, they can't please everyone every time. And that's just within the grain industry. Now, you talk with some of our coal shipping friends, and wow, you still have a lot of four-letter words.
There have been some service problems in the East, I think on one carrier more than the other major carrier. It's been the last 6 to 8 months, and some of it's power, some of it's manpower, as we understand. So I think it's being resolved, but it's slow to improve. So.
You mentioned about the shippers, the grain elevators becoming larger and larger to handle the large unit trains, and there's been some complaint that the railroads encouraged the elevator operators to build facilities to handle 50 cars, and then they've turned around and said, now we want 100 cars or 120 cars. But don't the shippers also benefit from these large operations in the sense of the economies of scale passed on to the shippers in terms of lower rates for loading cars?
Yes, they do quite often if they're fairly close to one of those facilities. I had a shipper friend in Colorado who was excited that recently they got a shuttle facility there, and they were excited about the lower rates. However, and I've heard the railroads say, well, if you're going to build a factory, you'd build it on a highway, on an interstate highway instead of out in the hinterland, but that's not where the wheat's grown. The wheat isn't grown on all the major railroads or near the shuttle facilities, and so getting it to those shuttle facilities still bears quite a bit of cost. And the small country elevators scattered out throughout the grain sheds throughout the country play a very important role and are very important to us.
Commissioner Mulvey, it's an interesting one. I mean, you were raised, or at least were in the Palouse Empire for a number of years in southeast Washington. The smaller elevators that the railroads encouraged in the 80s, 90s, and even in the year 2000 are very important for the marketing of the pulse crops, the rotational crops, the seed crops, the fertilizer crops. That isn't handled by the shuttles. And one of the worries in the country is, as these go away, where are we going to market these optional crops? And rotational crops, for if you don't know, are the crops that they grow in the off years because they don't have the moisture or they need to rebuild the soil. So there are concerns. Are people benefiting from the shuttles? No question about it. The concern we have is that maybe wheat is not quite the same as corn because the production quantity is not as much, and there may be instances where these smaller elevators are going to be very, very crucial to being able to market the crops that are actually being grown.
I have one final question to Keith, and that is, you mentioned a statistic that I quoted the other day in my talk out in Indiana, and that was that the rural market share in agriculture has declined from 50% to 35%. Would you care to speculate as to why that has happened, since the railroads have pointed to overall a fairly significant increase in their market share from 30 to 43% over the last, at least since staggers, while agriculture has gone down?
I think there's a number of factors involved. I think the industry has, the ethanol business, for one thing, in the last 5 years has grown from virtual zero to using about 5 billion bushels of corn. That's over a third of the crop. And we're not building ethanol plants very far from production areas. And so that's, a lot of that grain is trucked directly from the farm to the ethanol plant or to a local elevator, then to the ethanol plant. It never touches rail in some cases. And the industry, I think, has relocated some facilities because of rail pricing over the years, and so it's kind of taken away some of the market share that way. And barge movements are actually down slightly compared to 30 years ago. In terms of a percentage market share, barge used to pick up 20 to 22% of the market. Today it's down to about 17 to 18%. But I mean, we're just not exporting as a higher proportion of the crop as we used to, and some of it's because of ethanol.
But you see that changing, obviously, with what's going on in Australia and now apparently Russia with a locust problem. And so I gather that international output is going to be down again, which will probably be beneficial to agricultural export markets.
Well, I think the agricultural industry has a tremendous opportunity in the next 5 years to pick up market share in export markets. Some of that depends on transportation pricing. Some of it depends on production. We see ways that we could plant more acres, but it kind of depends on what happens in the farm legislation and the administration. But there's going to be an opportunity to pick up market share. Yeah.
Thank you very much.
Commissioner, can I add one more thing to your? We have whole states, though, that market 70-80% of their wheat export. Montana, North Dakota, Colorado. They're various states, and that's because they have very high-quality wheats. And so they are absolutely dependent on rail, and those percentages have not gone down in that part of the country. We're seeing the rise of the new white wheats, the hard white wheats. And as they come on board, they're going to be identity preserve marketed into Mexico and into the foreign markets also.
Thank you. Thank you very much. We appreciate your coming today, and we will now call forward panel number 6.
Should I do that? That was good. Yeah, do it. Yeah, just stick her in here. Stick her in here. There you go. Because then she'll throw them away. And you can give them to your wife. In lieu of a baseball game.
That's right.
Did you tell her about that baseball game?
Yes, thank you.
Excuse me. Sure.
You can begin. The chairman, I'm sure, will be here back in just a second. In the interest of time, I think we should probably just go on ahead. And I think we'll begin with Mr. Ward of the CSX.
Yes.
Thank you.
Well, thank you, Vice Chairman Begeman and Commissioner Mulvey. I'm proud to represent the interest of our key shareholders today, including the 30,000 dedicated employees of CSX. And I appreciate the opportunity to share our grave concern about the matters before you today. This is an extraordinary time for CSX and all North American railroads. We move more freight safely with record performance in the prevention of injuries and accidents. We work every day to make our railroads more secure from outside threats. And we're investing in our infrastructure at unprecedented levels, both to maintain our systems and to expand them for future demand. That's why today's proceeding is so important. The nation is struggling to build and maintain infrastructure, and our industry is doing that with nearly all private investment to ease the country's burdens. The nation desperately needs and is seeking new jobs, and we're producing them. In January, this administration launched an initiative to remove or streamline regulations that hamper business, dampen investment, or undermine job creation. We support that initiative. CSX is doing what the nation asked by investing $2 billion in 2011 to provide new transportation infrastructure, more than 3,000 new jobs, and an environmentally friendly solution to ease traffic congestion and reduce emissions. We're doing the right things for the right reasons with the right results. I'd like to make 3 important points today. First, capital investment, job creation, and the environmental benefits all line up with the goals of public policy. We continue to hear from federal, state, and local governments, from customers, and from communities we serve that there's a need to get more freight off the highway and onto the rail system. That's what we're doing. Second, we continue to make substantial investments in the quality, flexibility, and capacity of America's more important transportation infrastructure. At CSX, we spent $8.3 billion between 2006 and 2010 and plan to spend another $2 billion this year on projects to improve service to our customers, extend market reach, replace aging assets, and enhance the safety and security. In fact, we recently committed to spend 18% of our revenues on average on capital projects through the year 2015. And finally, our commitment is based on the existing regulatory framework, with the expectation of improving returns as we make our railroad more efficient and more productive. Any action by this board to limit long-term freight rail movements and force the opening of our private networks would artificially constrain profits and scale down our investment plans and job creation. I just sunk for some reason.
Oh, there's a thing on the side. Yeah, I did it.
You have to be careful with
Sorry
that.
if I offended you. You pushed the button on me for that last remark.
We have a little switch up here.
We compete vigorously against all of our competitors, but as the chart, which we hopefully will pull up here, the trucking industry has the greatest share of the traffic. It commands 67% of the total U.S. transportation market based on tonnage. Rail, on the other hand, currently holds a modest 10% of the surface transportation market. Customers often have sourcing or other options that further increase competitive forces. They can change sourcing for raw materials or use their purchasing power to encourage suppliers like railroads to lower their prices. We also face fierce competition from other railroads and rail truck transfer facilities, all the while creating competitive advantage for our customers. Over my career, I've seen the competition grow stronger. What's being sought here, in our view, is not more competition, but rather lower rates for a limited number of shippers. The Staggers Act gave the railroads the ability and the incentive to increase investments in their infrastructure, investments that today make the U.S. freight railroads the envy of the world and position North American commerce favorably on the global stage. Look at what's happened since Staggers Act. Volume has doubled, capital investment is at historic levels, and the railroads' improved health means that they're able to invest not only in maintaining and replacing their assets, but expanding capacity to handle the freight demands of the future. All of this new rail capacity eases the burden on publicly funded highways. You heard earlier this year about our National Gateway. Since that time, we've announced our intention to build a new intermodal facility to serve the Baltimore region and to complete a major clearance project on the Virginia Avenue Tunnel here in the district. That project alone is a $160 million rebuild of a century-old tunnel to enlarge freight capacity. Keeping what we have and building new capacity means more jobs on the railroads and the companies that support them. As I noted earlier, we'll hire about 3,000 people this year. That's more than the 2,500 we have been hiring per year since the year 2005. However, if we can't generate adequate earnings to invest in our networks and equipment to attract new employees and build businesses, it will not be possible to maintain our system as it presently exists. I'd like to look for a moment at railroads in terms of capital spending as a percent of sales and their corresponding return on assets. We'll look at this in the context of trucking and other industries, some of whom are represented by the companies or trade associations testifying before the board in this hearing. In the 5-year period between 2006 and 2010, railroads invested on average 16.9% of their gross revenue or sales. In turn, they earned a return on assets of just 5.3%. This highlights the capital intensity of railroads and the relatively low returns that are still not sufficient to justify replacing many assets. Every other industry on the chart invested less and earned better returns than the railroads. The proposed rules that transfer earnings from the rails to the shippers will only serve to exacerbate this disparity. We're proud of the National Gateway and other expansion projects, but a lot of our capital goes to decidedly non-glamorous but necessary items, everything from rock valves to cross ties. Every year, we have to maintain and replace basic infrastructure that's critical to operating safely and reliably. As you can see on this slide, these examples of the basic assets required to run a railroad. They're expensive to buy and to maintain. These decisions must account for significant costs of regular maintenance and upgrades. Any capital-intensive business, such as railroads, should be able to operate within a regulatory framework that provides the ability to earn returns sufficient to justify continued investment. Otherwise, railroads will be forced out of capital spending plans and reduce employment. Some of those testifying claim that railroads are driving manufacturing offshore. That's beyond belief. It's clearly in our interest to retain customers and to attract new ones. For example, the board's record indicates that some chemical shippers say that they're being forced to relocate their facilities abroad because of burdensome rail rates. Don't fall for it. The truth is the chemical manufacturers are in fact expanding their facilities and their production capacity within the U.S., and they're doing it on the railroads. We're attracting new business to CSX, and those customers are creating new jobs. This slide shows last year's results. If you look further back, the results are even more impressive. Since 2006, more than 600 new or expanded businesses have located on CSX and connecting short lines. That represents more than $18 billion of customer investments and more than 21,000 new jobs. That doesn't just happen by accident. CSX has a highly successful industrial development program to recruit new businesses. Our efforts are supported by the communities we serve, and those communities are often eager for new jobs, new sources of public tax revenues, and much-needed economic activity. Finally, this is what rail congestion is projected to look like less than a decade from now on our current course. To demand that the freight industry take on unprecedented feats of transportation, economic, and environmental performance, and then to impose new mandates and reassert the onerous hands-on regulation is an attempt to go forward and backward at the same time. It's the wrong direction, toward the past and away from the future. I've spent most of my career right-sizing our organization as well as rationalizing our network and our equipment. The railroad renaissance has changed all that. Today we're adding employees, expanding our network, and purchasing new equipment to the benefit of our country and our customers. We can do amazing things for our country. I know because we already have. We're converting freight from the highways to rail. We're reducing traffic congestion that costs billions of dollars in wasted time in travel and fuel. And we're improving the quality of the air we breathe and continue to provide an essential link for the U.S. military's logistics change to troops abroad. In closing, I'd ask you to remember two important numbers. 500. We can carry a ton of freight almost 500 miles on a single gallon of fuel. And 18. We will spend 18 cents of every revenue dollar on America's transportation infrastructure through 2015. The next few years could be a great opportunity for our nation if we align our policies and vision. There's a lot on the line. We've got to get this right by adhering to the tenets of the Stagger Act and the principles of balanced regulation we've been operating under over the last 30 years. Thank you.
Very impressive.
I hit the time thing even with the dump you did on me.
There's no throwing you. Thank you, Mr. Ward. We appreciate your comments. We'll next hear from Kansas City Southern, Mr. Haverty.
Okay. Chairman Elliott, Vice Chairman Begman, Commissioner Mulvey. I'm Mike Haverty, Executive Chairman of Kansas City Southern. I started in the rail industry 48 years ago, 1963, as a brakeman switchman on Missouri Pacific Railroad. I've been president of Santa Fe Railway, and I've been at Kansas City Southern now for 16 years. I've seen the good and the bad days in this industry. I was around at the pre-Staggers era and saw an industry on the verge of bankruptcy and nationalization. I also see the benefits of the Staggers Act and the rail renaissance that has followed. My main message to you today is be careful about what you do in response to this hearing. The ancient oath of Hippocrates, first do no harm, certainly applies to these proceedings. Given the actions the STB has taken in recent years to provide even better protections for shippers, you should let these improvements to your rate, service, and complaint process, a process that allows for specific remedies to specific problems to work. Recent decisions in favor of shippers show that the process is working. KCS is a vital competitor to the larger carriers, especially for traffic to and from Mexico. KCS also provides important rail-to-rail competition with respect to chemical traffic and grain movements from the heartland regions of Iowa, Nebraska, Illinois, Missouri, and Kansas to important markets in Mexico and the southeastern U.S. KCS also competes hard in the growing intermodal markets. KCS not only bridges transcontinental east-west traffic, but also handles cross-border international traffic to and from Mexico. No better example of what KCS is doing to better compete against larger carriers could be found than looking at our Rosenberg to Victoria, Texas line rehabilitation. KCS took a line that Southern Pacific allowed to deteriorate and spent over $170 million to rebuild it. It now serves a new intermodal shipper facility at Kendleton, and Caterpillar has recently chosen to locate a new manufacturing facility on the line in Victoria. This line would not have been built without this board's actions, which have helped KCS remain an independent carrier to the larger systems. In spite of its investments and growth, KCS still remains the smallest U.S. Class I carrier. As this slide shows, KCS domestic annual revenue is about 1/18 the size of our two larger competitors in the West, about 1/10 the size of the other two eastern carriers. Yet we compete vigorously in spite of our size disadvantage. KCS also plays an important role as an interline partner with all the other Class Is, and the vast majority of KCS's traffic is interline traffic. As this slide shows, approximately 85% of KCS's traffic is interlined with the larger Class I carriers. Because KCS interlines the vast majority of its traffic, has connections with every Class I carrier, and has critical interchange points with these carriers, KCS is uniquely at risk of being short-hauled in any bottleneck pricing scheme, having its traffic cherry-picked by the larger systems if some form of forced open access switching or terminal access were to be adopted. This could result in loss of an important rail competitor with the potential breakup of the KCS system. So as I said at the beginning, be careful about what you do, and first, do no harm. The unintended consequences of overreaching could be even further consolidation in the rail industry with even fewer independent carriers. For shippers who face legitimate market abuse, there is an alternative. I am pleased to introduce Mr. David Koschnick, a former member of the STB staff, to discuss that in more detail. David?
Thank you, Mr. Haverty. Chairman Elliott, Vice Chairman Begeman, Commissioner Mulvey. I'm David Koschnick, and I'm honored to be appearing here before you today. I began work at the ICC in 1976. During my years at the ICC and STB, I was involved in the full range of decisions made by the agency in railroad matters. I've seen what regulatory approaches have worked and what approaches didn't work, and I've always, especially since Staggers, been mindful of the agency's dual role to allow the market to regulate rates and services to the maximum extent possible while protecting shippers where there are market failures. The balancing of these factors is challenging, but in my experience, the agency has tried hard to provide a level playing field for all participants. KCS has retained me as an independent expert and not as an attorney in this proceeding. The views expressed here are my own. I've reviewed the initial comments and the reply comments, and in my view, the comments do not support a change in the STB's approach in matters of competition and access. It seems that the vast majority of the concerns expressed are about rates. That was in the comments. That's been confirmed here this morning. And I believe the board has processes in place to deal with those concerns. While I understand concerns, I can't support at this time calls for reversal of the mid-tech or bottleneck precedents. They were correct interpretations of the law. The underlying statute on which those decisions were based remains unchanged. Congress has had several opportunities to change the law so as to reverse these precedents and has declined to do so, which indicates to me that the board has struck the appropriate balance. Thus, I would not support a change at this time, but instead the board's existing procedures for rate and service complaints should be given time to be applied. I've seen firsthand how the agency has been responsive to shipper concerns and making changes. The board has been open-minded and flexible in considering concerns and in trying to improve the processes and make them more efficient and less costly where possible without sacrificing fairness to the parties in individual cases, all while endeavoring to remain faithful to the congressional charges contained in the Staggers Act and the ICC Termination Act. Here are some of the things the board has done to address the shipper's concern. The chairman mentioned some of these this morning. Commissioner Mulvey also talked about some of the things in revenue adequacy and cost of capital. In the SAC process, the board has eliminated consideration of product and geographic competition in making market dominance determinations. The board has adopted mandatory non-binding mediation to be conducted immediately after the filing of a rate complaint and improved the discovery process. The board has made changes to procedures to speed up cases, including elimination of the ability to make movement-specific adjustments to IRCs. In many respects, these changes sacrifice some of the accuracy of the original system in order to simplify the process and reduce the expense for all of the parties involved. Indeed, there have been several SAC cases over the past few years that have found in favor of the shipper, and sometimes that yielded large amounts of rate relief. In the non-SAC area, smaller shipments, in 2007, the board adopted simplified standards for the rail rate cases. In the service area, the board has improved both its formal and informal procedures for addressing service complaints and has improved its rail customer and public assistance programs. To sum up, the board has made many changes to shorten and simplify rate procedures and to increase shipper access to remedies for perceived abuses of market power by railroads. These changes have dramatically improved these processes and should significantly reduce litigation costs. The changes appear to be working. According to comments filed in this proceeding, since adoption of the simplified rate case standards, the chemical shippers have prevailed in 7 of 8 cases that have been brought under the 3 benchmark methodology, and of the rate cases that have reached final resolution since that time, 92% have ended either in a settlement or finding that the challenged rate was unreasonable. The board can adjust its procedures in the future if shown to be necessary. In the meantime, a case-by-case approach is best and safest. Any broad brush approach to competitive access at this time poses significant dangers that could easily present effects adverse to both railroads and shippers. I respectfully urge the board to resist the relatively few but nonetheless fervently expressed calls for a change in rule or approach by the board in matters of access. The best approach, it seems, is for the board to continue to handle these matters as they arise based on the specific facts in individual cases. Thank you very much for allowing me to appear here today.
There's a lot of pressure on Mr. Young, let me tell you. I will now hear from Union Pacific Railroad. Mr. Young, you have 10 minutes.
Good afternoon, Chairman Elliott, Vice Chairman Begeman, Commissioner Mulvey. Appreciate the opportunity to testify here today. Is it on? Appreciate the opportunity to testify here today. As you know, Lance Fritz, our Executive Vice President of Operations, was to be here with me today, but I thought it best that he stay in Omaha given the unprecedented flooding we're facing. As many of you know, we're looking at floods out there in the Midwest that are going to probably break the 150-year mark. So his job is to keep the railroad open and continue to provide the great service that we do to our customers here. I would ask you to allow us to submit a written copy of the testimony from Mr. Fritz. He will outline what you've heard today here several times, the potential consequences of access. Now, you know my background. I spent about 6-7 years raising money on Wall Street, and I'm going to give you a little bit different twist here from somewhat of an investor perspective. I'm going to focus on two closely related issues, and they are related: competition and investment. Union Pacific invests so that we can compete effectively for our customers' business. But to continue to invest, we must also deliver competitive financial returns to our investors. Shippers proposing new access remedies say they are trying to increase competition, but railroads are already subject to intense competition. Each year, we lose and must replace over 10% of our business. We continually struggle with other railroads, trucks, water carriers to win and retain business. Sometimes competition is easy to see because one carrier takes traffic directly from another. For example, just a few days ago, Kansas City Southern and UP won a significant coal movement from the BNSF. Our reply filing gave other recent examples of traffic switching between carriers. Other competitive actions are just as important. We compete by increasing the value we offer customers through high quality, reliable service, and innovative products. I'll just give you one example. The H.J. Heinz Company, we've been working with them to redesign their supply chain using refrigerated rail cars to shift traffic from highway to rail. Again, here's a boxcar product taking business off the highway, going to rail. We helped Heinz become more cost-effective, competitive, and environmentally friendly by reducing its fuel use, CO2 emissions, and costs. And this year, Heinz won the frozen food industry's Sustainable Supply Chain Award. Successes like this show why you can't measure competition by looking only at rates. You also have to look at the value we provide. Similarly, you cannot just look at whether traffic shifts between carriers. If our service creates enough value for our customers, they keep their business with us, give us more business, and are willing to pay for the value we provide. Competition is what drives us to invest. It's why we poured $30 billion into our network from 1999 through 2010. It's why we plan to spend $3.3 billion this year, $1.9 billion to replace and renew existing assets, and over $1 billion for new growth capacity. This is the highest capital spend in the history of Union Pacific Railroad. Competition is why we have committed to invest 17 to 18% of our revenue annually over the next several years, assuming the regulatory environment will allow us the opportunity to earn adequate financial returns. In short, competition is why we devote so much of our creativity, energy, and resources to improving service and expanding our network. As our earnings have grown, I've kept my commitments to our customers. So have our investments. We can't afford to ignore our customers, and our customers, at least most of them, recognize our efforts. Our customer satisfaction scores have been marching upward. In the first quarter of this year, we earned a record score of 91. The picture of a complacent monopolist that some parties paint does not fit with our approach to service, investment, and growth at Union Pacific. Proponents of new access remedies are not seeking more competition. They want policies that will shift revenue from railroads to shippers. These policies will also have the unintended consequence of increasing our operating costs, eliminating efficiencies, and consuming network capacity. The predictable decline in railroad earnings means that these policies would have a serious negative impact on our investment plans. Capital spending would decrease immediately, just as our nation is looking for railroads to provide more transportation capacity. This would reverse the progress we've made during the last 30 years. This is financial reality. If regulation prevents us from generating competitive returns on the replacement value of our capital investments, our shareholders will not allow us to continue investing at the levels we have planned. They will require that we return more cash to them directly rather than investing in future growth. Several parties in this proceeding say that stock buybacks and dividend payments are evidence that we're already earning more than we can profitably invest. They argue that we can easily spare this supposedly excess revenue without cutting back in capital expenditures. That's simply not true. Stock buybacks and dividend payments are not evidence of excess profit or lack of investment opportunity. Every company must balance between providing investors with immediate returns in the form of stock buybacks and dividend payments and investing capital for long-term value appreciation. We can't ignore shareholder demands that we allocate some of our cash to stock repurchases and dividends. Every one of the publicly traded non-rail companies that have filed comments in this proceeding and that has more than $10 billion in revenue bought back stock and paid dividends during the last 3 years. During that same time frame, almost 2/3 of the S&P 500 companies repurchased shares and nearly 3/4 paid dividends to shareholders. These are mainstream practices for delivering financial value to shareholders, not a sign of excessive profits as some commenters claim. We must compete for capital with other companies that provide the same type of returns to their investors. In fact, as you can see from this slide, comparing how cash spent on shareholders and capital investment has been allocated by Union Pacific and all S&P 500 companies, Union Pacific allocates a higher proportion to capital spending than to dividends and stock buybacks combined. In 2009, while we continued to invest significantly in capital expenditures, we had no share repurchase at all, while the S&P 500 companies allocated 19% to share repurchases. It's critically important for the board to recognize that using regulation to force down revenue and earnings will force down revenue, and earnings will increase, not decrease. Shareholder demands that we return cash to them instead of investing it. Our investors have questioned our need to reinvest 17 to 18% of revenue on an ongoing basis. In their experience, this is a significant amount of money for a company to invest. But recently, they've been encouraged by our progress in growing our financial returns. They're willing to stick with us as long as they see the opportunity for more attractive returns in the future. They expect our capital spending to pay off through higher stock price, stronger dividends, and share repurchases, which would increase the value of their investment. We're just beginning to meet those expectations. If regulation reduces Union Pacific's prospects for revenue growth, our investors will insist that we provide returns through higher dividends and more share repurchases now, rather than investing in growing the business in the future. Our capital expenditures will decrease. And as I said, this is a financial reality. Earlier this month, I met with shareholders and prospective investors at a major equity conference in New York. Our shareholders are very aware of this proceeding and its implications. They have a fiduciary responsibility to the pension funds, endowments, trust funds, and individual mutual fund investors who entrust money to them. If Union Pacific cannot provide competitive returns, many of our current investors will redirect their investment to companies that are not forced by regulation to reduce revenue. The investors who replace them and those who remain will not be satisfied with lower returns. They will press Union Pacific's managers to reduce investment base and cut costs by taking drastic actions such as slashing capital expenditures, selling assets, and cutting jobs. We all know the significant challenge our company faces to fund the high replacement costs of transportation infrastructure in this country. If our economy is to succeed and thrive in the global marketplace, shippers will need the rail network to carry more of the nation's freight. The board should be considering how it can encourage more private investment in railroads, not policies that will reduce such investment. With that, I'd be happy to take questions.
Thank you very much, Mr. Young. Thank you, panel. Vice Chairman?
Thank you all, and especially Mr. Young. We certainly would have understood if you needed to cancel today as well. We know that you have a very serious situation going on, as does BNSF. And if there's anything that we could do besides staying out of your way, you let us know. Certainly we've gotten sort of the collective message, which has been sent for years from industry, of sort of do nothing, make no changes, we need to reinvest, we need to earn adequate revenues, etc. You've also clearly have taken a very serious interest in this proceeding by not only showing up here today, but through all your lawyers and the submissions and tracking of what's going on here. I recognize you're telling us right now that even though you've been sitting through this process and hearing a lot of sort of uncomfortable complaints, at least if I was on the receiving end, I would be a bit uncomfortable. If the board is to do nothing, what can you do? What can you do to address some of the concerns that we've been hearing here today? I mean, I know that there are efforts where, I mean, we've talked a lot about competition, and if railroads are competing, I mean, can there be more of a use of, I think they're called Rule 11 rates? I mean, what more can be done so that some of these complaints can go away? I mean, shippers have some legitimate concerns.
I'll take a shot at first. Vice Chairman Begman, I'll tell you, what I experienced, I spent a significant amount of my time out in front of customers, probably a third or more. My experience in front of the decision makers in the field making those decisions every day, or senior people, is quite different from what we hear up here. Granted, I haven't met a customer today that will tell me, thanks for the price increase. They want lower prices. I would also like to have lower energy costs. I'd like to have crude oil at $30 a barrel, not 110. I'd like to have steel prices I'm paying that are up 300% over the last 10 years. I'd like to have my health care costs drop down to single digits. I'd like to have lower regulation costs that this industry is facing. But when you get through the discussion on the pricing, it quickly moves to this. What are you doing to invest and provide new products and great service for me in the future? I have been in hundreds of conversations with the senior leaders in many of these companies that are represented here today, and I always start with the price question because I want to have the discussion. But their biggest concern is when they look to the future and they look at what's happened with transportation infrastructure in the United States, and we know the story, their biggest concern is that we're not going to accelerate capital in this business. My goal is if you have a specific issue, and I'm not going to argue that we don't see some, we work with our customers. We very much work with them. I want them to grow. Putting a customer out of business or making them non-competitive in a market, that's exactly the opposite of our mindset. I need their business volumes for us to grow.
What I might say is that I think what a railroad can do is what I was taught many decades ago. You need to provide safe, efficient, and economical service. In other words, cost competitive service and on time. And that's really what it gets down to. And in our case, I think that we certainly have been able to do that. We have not had any rate cases against us, and we have not had shipper complaints, and I think that's what needs to be done.
Like I said, I'd like to make a few comments on that. One, you'll notice that the people who are here are those that want something to happen, i.e. their rates being lower, and the impression you get is this great discontent. I'm similar to Mr. Young. When I talk with customers, we have many, many happy customers. You'll notice over 100 customers who are not unhappy actually took the time to file comments in this proceeding. Normally people who are happy don't do that. So clearly there are a number of happy customers out there. I will remind the board that the Christensen study, when I looked at it, said there was no abuse of market power by the railroads. And they did note on the potential reciprocal switch was discussed earlier that would be the least onerous. They also did note that what will probably happen with that is it would lower the rates for a few selected industries, and with the resulting impacts of one of two things: higher rates for others and or lower investment. So clearly, even the board's own independent study said there's not an issue here of market abuse of power. So I think we have a selected group of shippers who basically want you to take your power to reduce rates when there's already a process in place to do that. We've been very pleased with your mediation process. At CSX, we've had 3 separate cases that were brought where the customer felt like the rates were not appropriate, and through your mediation process, we reach resolution every time. So there are procedures in place for those that don't feel like they're being treated fairly, and I think that we should continue to use those.
What are your thoughts on the board's arbitration process and getting it to function? Are you willing to participate, such as you do with the National Grain and Feed arbitration process?
Well, I think the processes you have in place today have been, in fact, I'd commend you for the changes that you've made in the STB over the last 7-8 years. I think you have to be careful making a wholesale change in terms of mediation. And I would, again, encourage our customers and process to look at what they can utilize today that's within their control. First point is start with the negotiation at the local level. We've had very few, if you look at over the last 4, 5, 6 years, where we've got to that point. because, again, my goal is to help a customer grow. And that doesn't mean that you may not have had a few situations you couldn't reach that agreement that's out here, but I think we have to be careful about wholesale change. We're saying we're going to offer, a new mediation process.
Well, there is an arbitration process that's been established years ago. It's just that it's never been used.
I think it probably hasn't been used because, again, we're getting a lot of the issues resolved, at least in the Union Pacific, out at the local level.
At CSX, we have over 4,000 customers, and the vast majority, 3,980 some, we reach a nice agreement with, and we work in a cooperative way to grow the business. So by and large, I think we do have good commercial relationships with the vast majority of our customers.
Could you go just a bit into the reciprocal switching issue that you brought up as far as the Christensen study, et cetera? And I know we haven't really talked about what a standard would be. It's just sort of a generic concept of if there were a change or a requirement for more reciprocal switching, what would be the actual impact be on your ability to provide your service?
One, we will have experts from the other railroads talking about the operational aspects of it tomorrow, and I'm not the expert to do that. But clearly there's significant issues around the capacity to be able to do this reciprocal switch work and continue to provide the service and capture the efficiencies of the single line service. Secondly, if you think about it, what it does, Ramsey pricing and the ability to differentially price your product is a key element of the Staggers Act and your policies over time. What you will start doing is start breaking that down. And without the profits that are available through the Ramsey pricing, we do not make returns sufficient to continue the investments we're making. Even today, with that ability, we're not yet revenue adequate as an industry. We're making progress toward that. So if anything, what that would do is start moving us backwards away from our ability to have that revenue adequacy to make those investments. And I'd like to reinforce Mr. Young's comments about the capital markets will clearly not allow us to continue to do that if we're seeing reduced profitability. So that to me would be the major impacts.
Yeah, I'd like to comment. We're about ready to substantially increase the amount of investment in terminals and industry tracks. This is our carload network that's out here. We're confident when we've looked at what our ability to get our returns up that it can justify investments. Now, these are investments you look at that are 30, 40, 50-year kinds of investments that are there to bring in or to put on the table uncertainty with reciprocal switching. I would have to step back and question, how do we think about those investments? You do need some certainty in this industry. When we're making the investments we're making today or when we look at the future 5, 10, 15, 20 years out, you talk about bringing in a cost-based method that's out here. You have to be careful of that. I think that's a solution. It doesn't take into account stranded costs. You have an investment. It doesn't take into account the replacement costs going forward. It would be disruptive in my mind on a wholesale basis. Again, we haven't defined how far you want to go or how broad, but again, we are and my customers that use the carload network, what they're looking for is even more investment in that terminal to industry segment. That, at least in the Union Pacific Railroad, particularly with Southern Pacific, had been ignored for years.
Is the concern primarily, whether or not you're paid sufficiently for that access, or do you have more of an operational concern, or is it a combination?
It's both. I mean, the thing about and you'll have some of the operating folks here tomorrow, but you clearly, one of the ways you can provide great service, improve your efficiency, is you have density. We can move blocks of traffic all the way into the CSX or Norfolk Southern off the UP Railroad. You start stripping that volume out where we're short hauling ourselves, you end up with less efficient and you have more handling. So there's an efficiency issue there. My concern is the decision on making investment in the future. The investment is generated by the over-the-road move. Investment in terminals would be very, very difficult to make for just handling a switch. The rates would be phenomenally high. Where we make the money is in moving that car over the road. So that has implications then on the profitability when you look at a particular geographic area.
Mr. Haverty, I'm sorry I interrupted you.
I agree with what Jim said. I think it is a combination of both price and service. And I do think that if a reciprocal switching agreement is in place today and for some reason it's canceled, I think that if the shipper thinks that they are not being treated fairly, then they have the right, I think, to come to the board. But I think to say that we are going to just open up access to all reciprocal switching is, in fact, an open access concept. And I agree with Ed Burkhardt earlier that testified. I was interviewed by folks from England prior to them privatizing their system. And this is right after I'd left Santa Fe. And they said, we're trying to figure out whether we should have open access or how we should do it. And I said, if you have open access, it will be a disaster because nobody's going to make any money, and you are going to have a safety record that is going to be horrible. And guess what? Nobody made any money. They had all kinds of accidents, and they renationalized the railroad in England. And I'll tell you what, I don't think we want to do that here.
Well, I'd like to make one comment, Commissioner Mulvey. You made a comment earlier about 50% of the reciprocal switches on CSX have been closed down. As best we could do through technology to try to understand that better, our initial read is that is not true. We have basically, when a business has gone out of business, we have closed that reciprocal switch, but no others have. And I will double check that and confirm that with you, but we could not verify that fact.
Go ahead.
Commissioner?
Thank you. Mr. Young, railroads, especially the UP, have historically invested in the segments of the market where competition is present, and you mentioned how competition is a driving force in your investment decisions. And in the UP, including the PRB, you've double-tracked to increase intermodal capabilities, et cetera. If competition drives investment, and if that's the case, why would you stop or reduce investing if additional competition is develops in other segments of the market, say, due to changes in regulatory policy, which promoted more competition? Wouldn't that spur on competition? I mean, a lot of the studies show that competition is the driving force of innovation. Studies, people still look at Japan and say, well, Japan has all this government-sponsored investment. And what people found, looked at it, was that, in fact, the Japanese had more competitive firms in the industries where they had the most innovation. And that's what gave them their advantage rather than government subsidies. So wouldn't competition drive more innovation at Union Pacific and more investment?
Well, Commissioner Mulvey, I think it's a function of how you want to define competition. My biggest concern is that we have artificial competition interjected into an industry that doesn't reflect the type of reality on replacing assets and return on capital that the market requires. I mean, that is the key when you look at this, where you're going to have we're not allowing the market to work here. We have made investment across our network. We don't differentiate between a single-served or an open location. You run a network, you have to invest. We made huge investments along the chemical coast, where you have some of the highest industries that are single-served. By the way, it's also an industry, in fact, our largest chemical customer down there, you may have noticed here the other day, announced a $1 billion expansion in chemical production on the Gulf Coast. A lot of that's on the UP Railroad. So it's great to say competition. I understand what's out there. My biggest concern is how we define it. And if it's an access provision that doesn't reflect the substantial cost of replacing assets or sunk assets, you're going to see this industry go backwards.
Some would suggest that if you had more open access, that the owning railroad would be able to charge the efficient component pricing situation, so that the owning railroad would at least be compensated for the loss of traffic. Would that be something that you would be willing to consider if you had?
Well, we had talked about that actually with Chairman Rockefeller in terms of a consideration there, but the fact is we couldn't get to that point in terms of the logic. That's why it broke down. But it really does reflect, again, when we're making investments. I'm double-tracking the Sunset Corridor today. And it's going to be, when we're all said and done, about a $3 billion investment between L.A. and El Paso that's out here. So, again, I think that you have to ask yourself the question, to me, Chairman Rockefeller, obviously I didn't agree with everything he said. I did agree with several points he made. He said the nation's facing a huge issue in terms of infrastructure in the future. Railroads got to be part of it. I think we all agree with that. But he also said the STB needs to think in the 21st century. I agree with that. And to me what that means, if you look at where we were, and Commissioner, you know this, pre-80, going bankrupt, 80 to 2000, an environment of substantial productivity, pricing to consume excess capacity, and then 2000, we hit a point that we woke up one day and we were tilt. And the UP Railroad probably fared the worst in 2003, where we had demand exceeded capacity. You're in a world now that I think you have to ask yourself the question, how do we incent more investment? How do we think about replacement costs going forward?
Mike, you mentioned about the return on investment that CSX gets versus we heard from before though that railroads were in the top 10% of all industries in terms of earnings, and your numbers suggest that it's somewhat less than that. You're more in the middle as opposed to being on top. But if that's the case, can you identify any needed investments that you're unable to pursue at this point with the revenue and capital that you have today? Are there any things you've postponed that you would do if returns were better?
Well, I think our industry well enough to know, Commissioner, when we start our capital planning process every year, so we're spending $2 billion this year. It's the most we've ever spent. The request list from our departments was about $3.5 billion. So there's always many very good, justifiable projects, but quite frankly, we are constrained by the financial markets as to how much we can afford to spend. So you'll notice at CSX and the industry in general, as we have earned more money, we have invested more money because I think we have a lot of very good projects to invest in. So clearly, I think the employees of CSX, if I told them we could spend another $1 billion, would have no trouble finding the ways to spend those monies on cars, locomotive, facility expansions. As you know, you mentioned about getting trucks off the highway. We're spending significant capital. We just opened a $175 million intermodal terminal up in Northwest Ohio. A lot of our growth capital is around the intermodal, which is growing at least twice the rate of the rest of our traffic. So we could find plenty of ways to spend more. I don't know how that measurement of us being in the top 10% of profitability, what that means or where it came from. I do know our returns are actually, while we've gotten much more profitable in the last 5-6 years, we're almost approaching the average for American industry.
Commissioner, can I comment on that a minute? I think you have to be careful about that statement, 10%. Unfortunately, in this industry, when you look at book value of assets, you look at operating margins and return on capital, the challenge, investors look at cash flow in this business. They look at future cash flows, discounted back. That's one way they look at evaluation. The reason they do that is because there's such a significant spread between the cost of capital, replacing assets, and what you have in the books. Example, UP this year, $3.3 billion in capital, depreciation is $1.4 billion. To give you some perspective on the pressure, we're like Mike. My number is $3.3 billion. The actual request list, and they had good projects, was over $4 billion. The real question I believe we got to ask ourselves is how much do we need? What should that rate be to meet the country's needs in the future? My belief is even though the industry has a record investment this year, it's still going to come close to what is projected out there. And one last item, it wasn't a coincidence that I came out of my annual shareholders meeting on May 1st and announced a new $3.3 billion all-time record capital in the same time to increase the dividend. That wasn't a coincidence in terms of shareholder support.
Thank you. Yeah, numbers are always interesting. They could be spun a whole bunch of different ways. For example, we had the railroad's percentage of tons compared to trucks. But ton miles, you get a different story. So depending upon how you're measuring it. And revenues, sorry to say, would be even lower then. So it really depends upon how it's measured. I have one question also for Mr. Haverty. You argue that you're much like the short lines, that you think KCS should be treated differently from the other Class 1s with regard to any kind of access remedies. You indicated that KCS provides an important competitive balance. But if KCS and the other carriers that might provide service on shorter hauls still exercise pricing power, why should the remedy be different for KZS than for the other Class 1s, if indeed you have the same kind of strength, pricing power strength anyway?
I think the point that we tried to make is that because we are smaller, and we clearly do connect with all the other railroads. In fact, we are the only railroad in North America that connects with every other railroad in North America. But if you go to total open access, because we are so much smaller and don't have the longer hauls that some of the others do, what we are concerned about is that they can come in and cherry pick our business and basically put us out of business, and then we are no longer really a viable competitor. And today we are a viable competitor.
I think the average length of haul for all railroads, Class 1 railroads right now, is 919 miles, according to the AAR's Yearbook of Railroad Facts. Do you know what it is offhand for the KCS network, including the Mexican portion?
With the Mexican portion, that has increased now to we're up probably about 750 to 800 on that kind of a haul. When we had just the U.S., it was less than 500. It was about 450.
Thank you.
Yeah, I don't really have any questions. I just have one thought. I know we've been, there's obviously a difference, between what the shippers are saying and what you're saying to us, and I think that fight has been going on since the Staggers Act has basically been put in place, and it's probably been going on way before that for the last 100 or so years. And I don't know if there is, a certain way of resolving it, especially, taking out all the contingencies and things that could possibly happen if we do some kind of access remedy. But what I did notice in one of the filings, and I asked people to bring ideas to me, and one of the filings brought up an idea of a pilot project with reciprocal switching, and obviously there would have to be some kind of ability to control that project, like in any type of experiment. But I would wonder, in the interest of maybe finally resolving this thorny question that people have been fighting about, would the railroads be amenable to something like that, where, of course, if it was possible, that it could be controlled in some manner, would they be amenable to taking a look at a pilot project and seeing if it creates a useful competition, and in fact what the shippers have been saying all these years is correct, or if it really shows what the railroads have been saying is correct, that they're not going to be able to invest properly. And especially, I've heard with respect to reciprocal switching areas that when you bring somebody else in using your own property, there's really no incentive to invest, and if it starts deteriorating as a result. So that's kind of my question, is would that be something that would be of interest to the railroads?
I'll be glad to go first, Jim. No, it would not be of interest to the railroads.
Should have made it a shorter question. And why is that?
Well, I think for some of the reasons you noted, that terminal infrastructure, as Mr. Young said, that you make your money on the long haul, but terminal infrastructure you would not do of its own accord. So you're going to be turning those assets over, increasing the operating complexity, which you'll hear about tomorrow. And I think it was Mr. Hamburger noted earlier, they do have that in Canada, and some of the customers up there are still unhappy because it's about rates. It's not about access. And you have remedies in place to deal with rate issues in the current regime. So I think it's a solution searching for a problem that already has a solution called your procedures.
I think that the issue you run is what signal are we sending to the markets in terms of, we're going to experiments in this industry, I think can be a real problem in terms of what you expect in the future. If we're running an experiment, I can guarantee you when I'm in New York talking to the rating agencies on our bonds, they're going to be asking me, where's this going? What does this mean? I would argue you have it within your control today in terms of looking at the competitive issues in many of these areas. I would ask you to think about
competition in many of these areas. Transloading, it was touched on a little bit. It's one of the fastest growing businesses we have. I know the BN is doing it because they've been a very effective taking business from me. So you've got to, I think, be careful when we think about rail to rail. That is a form, it's truck to rail, but it is very, very effective and seeing it growing very high in the business.
Now, with the markets, or the people that you're talking to, the analysts, if we came to some solution and the only thing we were looking for is the correct solution, the solution that worked, as opposed to having proceedings like this every 15 years, which just seems to be what we do. And wouldn't that settle the markets better than just having this unknown out there?
Here's what the markets want. They want our returns to consider the replacement cost of assets. So you have to think about that, and I know we have debated it for a long time, but the fact of the matter is the reason that my shareholders are not reacting negatively today to the $3.3 billion investment is we've delivered reasonable returns, but the focus is in the future. They're questioning, when you're putting $3.3 billion into the business, are you going to be able to price and earn the kind of return on capital that you need going forward? And that return on capital number, when you think about the replacement cost of assets in this business, last year UP reported about 10.5%. If you take a reasonable methodology, depreciated new, in terms of calculating return, it's about half that. That's their concern. They see this significant requirement, and unfortunately, we've been living off the past. Chairman, I'll let you know I've got a project in Mississippi River, 103-year-old bridge, swing span bridge. It's closed 4 to 6 hours a day on one of the busiest rail corridors in the world. We're going to replace that if the government helps us get the permitting done. It's a $400 million investment. Those are the types of things that are out there.
Just to reinforce that, I know you have some Wall Street experts coming to speak to this hearing. The first question you asked me is, what about replacement cost? That is constantly on their mind because they are looking at the vast sums that we're going to have to do to replace these older assets.
Thank you very much for coming today. We really appreciate you taking the time. And what we're going to do is it's 5 to 2. I think we're going to take a 45-minute break since we're going a little slower than we thought. Very verbose bunch. So remember to take your badges with you because you'll have a difficult time getting back in. So thank you.
We don't need no sticking mic.